Just tell her that he's just not gonna get well. We're sitting here waiting for this Zoom stuff.
Hang on. All right, we're now streaming live from the court's YouTube channel. The courtroom doors are open, as well as the camera here is showing those in the courtroom. Mr. Garcia, I still cannot hear you, but yeah, it's connecting to audio now. So we're moving to the next case, and then we'll come back to the state of Texas and Muhammad. So right now we're on the DF 1505396, state of Texas versus Michael Reyes Jr. Okay, Mr. Reyes, you can come have a seat here. And ma'am, you're the movement, right? You can have a seat right here behind your attorney. All right, and this is on a motion to revoke. Is that correct?
Yes, ma'am.
All right, counsel, did you send notice to the Office of the Attorney General?
Oh, yes, ma'am, we did.
Okay, I do not see him. I have the exhibit, yes. I'm not sure if the state planned on attending, but they did send over state's exhibit A, which is the payment record.
They did. We have it. Yes, yeah, it's one of our exhibits. I should tell the court first that it's my understanding that Mr. Reyes has chosen not to appear today. He told me yesterday.
He's here.
He's here?
Yes.
I'm sorry.
Yes, Mr. Reyes is here. He's sitting at the respondent's table. Let's see, I have the proposed order to revoke the probation as well.
Yes, Your Honor.
Mr. Reyes, are you representing yourself?
Yes, ma'am.
Okay, have you had an opportunity to review the proposed order to revoke your community supervision?
What does that mean?
So he filed an order. So you're on probation, right?
Mm-hmm.
There was an order filed to revoke your probation, alleging that you haven't been complying with whatever the court's order was, which is for you to pay child support. And they're asking that your probation be revoked today and that you be placed in custody and taken to jail. So my question was, have you had an opportunity to review that order that is asking me to revoke your probation and place you in jail?
I didn't know about none of this stuff and about the probation stuff. I don't understand this court stuff. And I mean, they did mention the last time, but I didn't know what I had to do. I didn't know it was just the probation was placed on me. But
Okay.
I tried to talk to them, and I mean, I talked to Maria, I talked to Mr. Jerry. I mean, it's the reason why I have not paid right now.
All right, we had a hearing back in, was it June? June the 2nd, counsel?
Yes, that's right, Your Honor. And the parties had agreed to reschedule that hearing to today.
Okay, and I'm looking for hold on, here it is. The second motion to revoke the suspension.
Yes, Your Honor.
All right. So when we were here the last time, Mr. Reyes, we reset the hearing in June.
Ma'am.
So that's what you're here for today.
Yes. Yeah, the last time I was supposed to get a lawyer, but I mean, at the same time, it was the money stuff, and we right now we came to an agreement. The web Maria, we came to an agreement, and I mean, hopefully, if it works right there.
When you say you all came to an agreement just like this morning?
No, it's already bad. No, not today. It's just we already been talking right now. Just past months, few weeks, we've been talking, and we came to agreement.
Okay, ma'am, have you discussed that agreement, bless you, with your attorney? Because if that's the case, then I'm not sure what I'm supposed to be doing. Have you spoken to your attorney about the agreement? So counsel, are you still trying to move forward with revoking his suspension?
We, we are, Your Honor. Mr. Reyes has failed to make, well, various payments that were ordered for him to make, in accordance with the, order that was entered by the court last year. And,
Right, I understand that part. I guess I'm trying to see, was there an agreement to proceed with today's hearing? Or was there an agreement for them to work out whatever it was that they have come to, and then he just pay according to that? Because I don't want the court to be involved in any agreement between the parties, because that doesn't allow them to actually agree in good faith. Because if the agreement, and I don't know the agreement, right? But if the agreement is between the two of you for him to pay you X amount of dollars at a certain time, you all understand that there's an order that's still in place, right? And although you come to your agreements, the underlying order hasn't been changed. So, I guess the court needs to know what you all's agreement is, because if your agreement is going to be between the two of you and for him not to go to jail, then that needs to be put on the record. And the attorney needs to clearly understand that, because that's not what he's saying. He's saying he failed to pay child support as ordered last year, and he's trying to proceed with this motion.
well, not only child support, but medical. Past due medical and attorney's fees that were ordered last year to be paid. He's paid some of the attorney's fees, but not any of the child support or medical or past due medical.
Okay, so what I'm going to do is I'm going to go back to my 9 o'clock case that is here on Zoom, and I'm going to allow you all to speak, because I don't want to infringe on any agreement between the two of you. An agreement between the parties is presumed to be in good faith, and I want to make sure that I honor whatever you all's agreement is, as long as I'm allowed to within the realms of the law. So I'll give you all an opportunity to speak in the conference rooms.
Thank you.
You're welcome.
So you want us to go in the conference room or?
Yes, the conference room. So that way you all have some privacy, because we are going to start this hearing. I don't want to interrupt you all.
Thank you, Judge.
You're welcome.
Yes, Your Honor. Thank you so much.
You're welcome. No problem.
Okay.
All right. So we're going, Mr. Garcia, can I hear
Can
you?
Can you hear me now, Judge?
Yeah, welcome.
I think my phone my computer connected to my phone and it was on silent.
Oh, yeah, that does happen. That does happen. Okay, so we are here on, let me make sure I have your exhibits. I believe I do. So I have the payment record, an order appointing an attorney, and an order for a capias.
Yes, ma'am. The capias was in the event,
Am I
Mr.
right here?
I'm sorry.
Go ahead, counsel. I'm sorry.
Oh, I said the capias was in the event Mr. Muhammad didn't show this morning, but he's here and he will need a rights hearing. This is his first
Okay.
appearance.
Okay, that was my next question. All right, you ready, Joey? Okay, we're on the record in cause number DF 1113588. Counsel, will you please announce for the record?
Your Honor, Matt Garcia for the movement, the Dallas County Domestic Relations Office.
All right, and Ms. Muhammad, would you please announce for the record?
My name is Lantiette Michelle Muhammad.
All right, and you're one of the respondents in this case who will be representing themselves, is that correct?
Yes.
Okay, and Mr. Muhammad, will you please announce for the record?
Yes, Jihad Hassan Muhammad.
All right, and you are also one of the respondents who will be representing themselves, is that correct?
Yes, ma'am, that's correct, Your Honor.
All right. I have before me there's a motion to revoke. I'm sorry. There is a motion for enforcement of child support. And Mr. Muhammad, a rights hearing is where, by law, if you're unable to afford an attorney, I have to ask you a series of questions to see if you qualify to be court-appointed an attorney, okay?
Yes, ma'am.
The motion for enforcement is quasi-criminal, meaning that it has a criminal component to it, where if you're found to be held in contempt, you can actually be placed in jail. So before legally I am able to even take that consideration up, I have to see if you're entitled to a court-appointed lawyer, okay?
Yes, ma'am.
All right. Would the both of you please raise your right hands? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
I
Yeah.
affirm.
Thank you. Mr. Garcia, did you want to go ahead and ask Mr. Mohammed questions?
Sure.
Okay, go ahead.
Mr. Mohammed, state your name, please.
Yes, Jihad Hassan Muhammad.
And Mr. Mohammed, you understand what the judges told you about the case being quasi-criminal and the possibility of you going to jail, correct?
Yes, I do.
Are you able to hire an attorney?
Not at this time, no.
Okay. Are you asking that the court appoint you an attorney?
No, I'm not.
So you're going to represent yourself and risk the possibility of going to jail?
Um,
It's a yes or no
Yeah.
question.
yes, I don't think I need an attorney. No, sir.
Okay. Do you have any legal questions at this time?
No, sir.
Okay. Okay, I pass the witness, Judge.
Okay, so Mr. Mohammed, I just want to make sure I'm understanding you correctly. You do not wish, this is a rights hearing, okay? So it has to be determined whether or not you qualify for a court-appointed attorney. So I need to make sure that I understand you affirmatively that you do not wish to seek a court-appointed attorney. Is that correct?
Yes, ma'am.
Okay, so you wish to proceed today representing yourself against the state.
Yes.
Okay, all right. So that concludes the rights hearing. Counsel, I have 3 exhibits from you that, well, technically
Good.
1 exhibit that was pre-admitted, the pay record.
Judge, do you think you could stick us in a room? I might be able to just settle this so we don't have to have a hearing.
Okay, yeah,
Pick up the court's
I
time.
have no problem doing that. Let me
Great,
get you.
thank you.
You're welcome. You all will get a prompt to, let me see, there we go. You all will get a prompt to start going over to another room, so just join it.
Okay. Yes, ma'am.
Okay. 2, 2. Counsel, I want to make sure I pronounce your last name right. Is it Anunobi? Okay, I can't hear you.
I said, yes, Judge, you sure did. Good morning.
Good morning. So I said it right?
Yes, you did.
Okay, great, great. And Hillary, is it Amakwe?
Wow, very good.
Yes,
I
thank you.
practice a lot. I practice a lot. Let's see. All right. And then I believe Mr. Muhammad coming in now. Okay. I have exhibits too. I have 1 through 10, 17, 21, and 22.
Yeah, we sent you 22 exhibits. Some of them were audio or video, so I don't know if those are the ones that you're missing.
Okay.
Which ones did you say you have? Let me mark.
I have 4 different emails. So the first email is 1 through 10.
Okay,
The second email is Exhibit 17, which is an audio.
okay,
The third email is Exhibit 21,
okay,
and the fourth email is Exhibit 22.
okay. So we are missing exhibits 11. Okay, so
They'll send you. You didn't send me that on either one of them. Okay, I'm sorry. I got the first one. I didn't get the second one. Oh, I see it. Okay. Thank you. I have it. So I have Stace exhibit. I have the Stace exhibit. So council, all the exhibits I have are 1 through 10, 17, 21, and 22. That's
Okay.
what my court reporter has. So we need 11 through 16, and then 18, 19, 20, and that's it.
Okay, all right, we'll send it, we'll send this over immediately.
Okay. You have
right.
some time to go ahead and get that done because everyone is here.
Okay.
So if you could get that now, so when I go on the record, I have them in front of me to admit them, that would be great.
Okay, sure, we'll do. I thought my staff was on this call, but I guess she's not. Let me do that right now. What email? What's a good email address to send it to? I'm so sorry, Judge.
You can send it. That's okay. Joey, can you see Joey's name on there?
Yes.
Yes, it's her first name, period, her last name at dallascounty.org.
Okay, perfect.
And you know what? Mr. Garcia gave me a good idea. And I forgot to mention this. Have you all had an opportunity to speak about settlement possibly?
Yes, this case has been going on for a long time and it has not been successful.
Okay.
So Joey Rivera, no dot in between?
Yes, Joey.Rivera at dallascounty.org.
You know, it may be more than one email because of the size of the files.
Okay. And that's fine. Ms. Amakwe, are you representing yourself?
No.
No, I'm her counsel, Judge.
Okay, I'm sorry. I'm looking at the motion. It has Attorney Pedicini on here. So, Mr. Muhammad, are you representing yourself?
Good morning, Judge. I'm. How you doing today?
Good. How are you?
I'm doing all right. I literally just got off the phone with a lady that I have that's going to represent my case. It just took me a while to find the right attorney, and I mean, I've kind of looked over this case, and with everything going on, I know I have a right to an attorney. So I was trying to see if there's any way we could get a slight continuance so I could catch her up to this case and retain her. Literally just got off the phone with her, and and that's what she told me to ask if that's possible.
May I be?
They agreed to take on my case, so I just need a slight continuance, Your Honor.
Okay, counsel.
Judge, the challenge is this is yet another delay tactics. This case has been going on for a very long time. The respondent was evading service. It took a long time. We ultimately got her served. He's known about this matter. There's been motion to compel. He's disobeyed the court order even in doing that. And then now we're here today. My client, they have two little kids together that need support. She's not getting any support. This is becoming very expensive. He's doing this over and over again. And so we're going to oppose any kind of continuance because he had more than enough time to find counsel to be able to represent him in this matter.
Okay, and maybe I'm looking at the wrong, are there competing motions for enforcement?
No.
Your Honor.
Hold on one second, sir.
Yes,
I see
ma'am.
motion for enforcement for child support that was filed in November by your client. Correct?
Yes, Judge.
Okay, is that the only enforcement? Because I see another one that was filed last year for possession and access.
That's not the one we're here on. We're here on the one that was filed almost a year ago on the 26th of November of 2024.
Okay, let me make sure that I don't see any service on that one. Sir, did you serve her with your motion for enforcement?
Yes, sir. Yes, ma'am. I wanted to actually get some rights to be able to see the kids because she wasn't letting me see them.
Okay, that wasn't my question. Let me ask a better question. So what did you do, if anything, to put her on notice of your pending motion for enforcement?
I had counsel about a year ago, so we went to court about the situation.
I don't see anything on the computer showing service. Counsel, did you see anything for service on her?
No, I do not. I do not believe that she was that service is perfected on her, Judge.
Okay, I was making sure I was reading it right on the computer. So let me see. This was filed. So service was perfected on him, just August of this year. So this was
Yes,
the first time that you all have come to court.
that is correct, Judge. We had a difficult time getting him served.
Okay, I got it. So what we're gonna do, we're gonna go on the record and have a rights hearing because he hasn't had a rights hearing. So even if the court would have to entertain, if he qualifies for a court-appointed attorney, I have to reset the case anyway to appoint him an attorney. So that a continuance, sir, you may get it anyway, just by default, okay?
Thank you, Your Honor.
You're welcome. Everyone ready?
Yes, ma'am.
Okay. We're on the record in cause number DF2100818, State of Texas versus Mohammed, is it Usman?
Yes, ma'am.
Okay. Counsel, will you please announce for the record?
My name is Chidi Ananobi, and I represent the movement in this case, Hillary Amakwe.
Thank you. And Mr. Usman, you are the respondent in this case and you are representing yourself. Is that correct?
Yes, ma'am.
All right. Would both parties go ahead and raise your hands? Your right hand? Yes. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am. I do.
Yes.
Thank you. You may lower your hands. Okay, sir. We are set here today on a motion for enforcement. before beginning any enforcement hearing, we have to have what's called a rights hearing. And that's where a series of questions will be asked of you to see if you qualify for a court-appointed attorney. By law, if you do qualify, I have to appoint you one. If you don't qualify, then you are welcome to hire your own attorney, okay?
Yes, ma'am.
Okay, counsel, you may proceed.
Sir, could you state your name for the record?
Muhammad Usman.
Okay. Mr. Usman, you are the respondent in this case, is that correct?
Yes.
Okay. And in 2023, you had your W-2, your 1099 show that you made over $122,000. Is that correct?
I object, Your Honor. Your Honor, I do not want to answer any questions without proper, without.
You cannot do that. You cannot have it both ways. You either answer the questions for your rights hearing, or we have to proceed. Like you
Okay.
can't both ways. I have to, by law, I have to determine whether or not you qualify for a court
Yes,
appointment.
yes, ma'am. Yes, ma'am.
Okay.
Go ahead, Judge. I mean, what'd you say?
I'm sorry, I was waiting for you to finish. I did not want to speak over you.
No problem.
Okay. I asked in 2023, your 1099 shows that you made approximately $122,000. Is that correct?
It's not correct exactly, because taxes as well. When it comes to the taxes and everything else, I did not make that.
I'm going to be very clear now. Your 1099 in 2023 showed that you made $122,000 approximately. Is that correct? Yes or no?
Yes, that's what it showed.
Thank you. And before Judge Lee, I believe, when we were doing one of the motions to compel, you indicated to the court that you had a big fight in June. Is that correct?
Yes, I did. I had a regular fight in June. Yes.
Okay, and you indicated to the court that based on the earnings from that fight that you were going to be able to make payments towards your child support and towards the attorney fees that you were ordered. Is that correct?
Yes.
Okay, and you did not, and you had that fight. Is that correct?
I did have that fight.
And you won that fight. Is that correct?
I did win that fight.
Okay, and you did not make any payments towards child support following that fight. Is that correct?
Yes, I did. Money comes out of my check per each fight for child support.
Is your testimony before the court that you actually made payments to her towards that child support?
Yes, money came out of that fight for child support.
All right. So, how much money did you make in that fight?
Roughly about 34,000.
Okay. And how many fights have you had this year?
That was the only fight I've had. I was supposed to have another fight October 11th.
Objection now responsive after. That was the only fight I had.
Sustained. Okay, sir, wait on the next question.
Yes, ma'am.
All right. So and you have, how many followers do you have on your Instagram?
I have over 200,000 followers.
Okay. And what other social media do you have?
That's it.
Okay. And do you make any money from your Instagram?
Not at the moment.
Have you ever made money from Instagram?
When I had sponsors, yes, I did.
Okay. When was the last time you made money from Instagram?
I made money from Instagram. I had a sponsor, Peaks Curative. I was making roughly about $1,000 a month from them to advertise their supplements.
Okay. Objection now responsive.
Sustained.
The question was, when was the last time?
The question was the last
Okay.
time you made money from Instagram.
No, it's been a while. I can't even recall. It's been a while since I made money from Instagram, Your Honor.
Are we talking a while as in 2 months? Or are we talking a while as in 6 months?
We're talking a while as in 6 months plus, over 6 months. I have not made money from Instagram.
Are we talking a while as in 1 year?
Close to it. It's roughly over 6 months.
Roughly over 6 months. Okay. So it's true that you fly private jets. Is that correct?
No, it's not true that I fly private jets.
Okay. It's true that you party in fancy restaurants. Is that correct?
No, it's not true that I party in fancy restaurants.
Okay. Um, so if I were to show you an exhibit, a video of you at a club in with half-clad women and big stuff saying Niger boys, would not be a part you and your friends?
Yes, that'll be me out celebrating my birthday, and then they hosted me. So a lot of the things, as you know, with what I do, I host events. So that does not equate to money.
Okay.
Hold
So
on 1 second. Hold on 1 second, Counsel. This going outside the scope of
okay.
his rights hearing.
Got you. You're right, Judge. You're right, Judge. Okay. So at this point, Yon, I'm going to pass the witness.
Okay, Mr. Usman, what is your income right now?
Nothing. That's why it's been such a struggle for me to get a lawyer.
All right.
Literally nothing.
This year, this is October. From January through September, how did you make money?
I had a fight. I had a fight in March. And I had a fight in March, and that was my last fight. I was supposed to be making a fight. I was supposed to have a fight October 11th that got pulled due to an injury. So, and that's what makes it kind of hard with what I do. It's not even a 9 to 5. It's if you're not fighting, you don't make money unless you have sponsors. So that's really where I'm at this point. And or I've been looking to get a job because I mean I can't live like this forever. So I'm at a point in my life that it's like, yes, I'm looking to get a job. I'm actually in school right now to be an insurance broker. I'm doing everything I can to try to put myself in a better position than where I'm at now. So I am currently I'm currently jobless, basically, until I get this handled.
All right. Where do you live?
I'm currently in Florida where I train.
All right. Who do you live with?
At this very moment, I'm staying with a friend.
What type of bills do you pay, if any?
My phone bill. Roughly try to pay my phone bill, and that's about it right now. I'm struggling a little bit.
So the fight that you mentioned, the 34,000, is that the one in March?
Yes, ma'am.
And your testimony is that that's the only income that you've had
Yes,
all
ma'am.
year thus far?
Yes, ma'am.
Okay. All right. So, Counsel, do you have any other questions?
No, ma'am, no other question.
All right. So, based on your testimony, sir, the court is going to find that you are indigent. The court is going to court appoint you an attorney, which means that this case is going to be reset. You're going to be responsible for reaching out to your attorney. I'm going to sign the order today. That's going to be an attorney through the public defender's office. On that order, it would have their phone number as well as their email address for you to contact them. Now, if you fail to contact them for any reason and the hearing is reset and you show up without them, that is 100% on you, okay?
Yes, ma'am.
So you make sure that you reach out to them. I have contempt hearings on Mondays, counsel. The earliest available that I have to at least give enough time to bring the public defender's office up to speed will probably be November the 3rd or November the 10th.
Okay. The 10th looks better, but let me pull up my calendar real quick, Judge.
And sir, November the 10th works for you, right?
I'm looking at my calendar right now too.
You don't have any fights or anything scheduled, right?
No, I do not. I wish. No, that's perfectly fine, Your Honor.
Okay.
May I respectfully ask that he be sworn to return on November the 10th?
Yes, he will be.
Okay.
Are you asking for the hearing to be in person, or are you asking for it to be via Zoom?
Zoom is fine, Judge.
Okay. Let me tell you the times that I have available left. I have 10, 10:30, and 11 o'clock.
10 o'clock is fine.
Third, 10 o'clock work for you?
Yes, ma'am. 10 o'clock works.
All right. All right. So, Mr. Usman, I am swearing you in to reappear on Monday, November 10th, 2025 at 10 o'clock a.m. You'll use the same Zoom code that you used today, 688-044-0164. As I stated, you will be appointed a court-appointed attorney from the Public Defender's Office. Make sure that you reach out to them by phone and email and make contact. They'll receive the other information from the court related to, the calls number and everything like that. Your failure to appear on Zoom that day may result in a KP's warrant being issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Do you have any questions about those instructions?
No, I do not. Thank you so much.
You're welcome. Thank you all. You may be excused.
Bye-bye.
Thank you,
All right,
Judge.
Attorney Garcia, were you all able to come to an agreement?
Yes, Your Honor.
All right, great. So let me get everybody back on. Everyone's cameras are on. And thank you all for working that out. I believe that the best settlements, the settlements when people come to their own agreement, those are the best because you'll follow an agreement. You're more likely to follow an agreement you come to versus one that I tell you you have to do, right? So thank you all for working together on that. Everyone ready to proceed?
Yes.
All right. We're on the record in cause number DF 1113588. Counsel, will you, we already announced and everything. So we're just going back on the record. The parties had an opportunity to step into a breakout room and they have come to an agreement. Is that correct, Attorney Garcia?
That is correct, Judge.
All right. If you would go ahead and read the agreement into the record.
Sure. Your Honor, I ask the court to take judicial notice of the prior orders and pleadings on file.
Thank you. The court takes judicial notice of all contents of the court's file.
Thank you. And enter into evidence what's been marked as State's Exhibit Number 1. That's a copy of the child support payment record for Jihad Muhammad.
It's submitted.
Thank you. Your Honor, the agreement is as follows. On January 26, 2012, this court ordered Mr. Muhammad to pay child support. Mr. Muhammad failed to do so. As a result, he's in arrears $34,492.99. That's as of September 30, 2025. The parties are asking the court to order a judgment in that amount against Mr. Muhammad and in favor of the movement, the Dallas County Domestic Relations Office, that judgment to attach interest at 6% per annum. Mr. Muhammad agrees to pay that judgment by paying $550 per month beginning December 1st of 2025. He will pay that amount each first day of each month thereafter until that judgment is paid in full. The parties agree that all payments should be paid through the State Disbursement Unit in San Antonio and that all payments be subject to income withholding per state law. The parties agree that Mr. Muhammad should be held in contempt, punitive contempt for failing to pay child support on June 1st, July 1st, August 1st, and September 1st on the year 2024. The parties are asking the court to order that Mr. Muhammad be committed to the Dallas County Jail for a period of 180 days for each violation. That sentence to run concurrently. Mr. Muhammad agrees to pay a court fine of $100 to the movement. He will pay that on or before February 28th of 2026. Parties agree that Mr. Muhammad should be held for coercive contempt as he has the ability to pay child support the day of this hearing, and that he be committed to the Dallas County Jail until he's paid $3,500 toward the child support arrears judgment and the court costs. The parties are asking the court to suspend commitment to jail and place Mr. Muhammad on community supervision for a period of 65 months beginning October 2025. The parties, as terms and conditions of community supervision, Mr. Muhammad will pay the arrears judgment as agreed, pay the court costs, pay the court fine, and any other conditions the court may place upon him. Mr. Muhammad agrees to pay court costs as billed by the Dallas County District Clerk's office, and that is the extent of the agreement. And Judge, may I call Ms. Muhammad?
Yes, you may.
Ms. Muhammad, can you unmute yourself?
Yes.
State your name, please.
Lantiat Muhammad.
Ms. Muhammad, did you hear the agreement as I read it into the record?
Yes.
Is this indeed your agreement?
Yes, it is.
And are you asking the court to enter the agreement?
Yes, please. Yes.
As the witness.
Okay.
Call Mr. Muhammad.
Yes, sir.
State your name, please.
Shahad Hassan Muhammad.
Okay, Mr. Muhammad, did you hear the agreement as I read it into the record?
Yes, sir.
And is this indeed your agreement?
Yes, sir.
And again, I informed you had the right to counsel before we came back before the judge, right?
Yes, sir.
And you continue to agree that you are going to proceed pro se.
Yes, sir.
Okay. And did anybody force you or coerce you into entering into this agreement?
No, sir.
And are you doing so freely and voluntarily?
That is correct. Yes, sir.
And you're asking the court to enter the agreement, correct?
Yes, sir.
Judge, I pass the witness.
Thank you. Any other witnesses, counsel?
No, Your Honor.
All right. Ms. Muhammad, this is in fact, your agreement today. Is that correct?
Yes.
Okay. And would you like for me to enter that agreement into an order?
Yes, please. Yes.
Okay, Mr. Muhammad, if I were to ask you the same questions I just asked Ms. Muhammad, will your answers be yes?
Yes, ma'am.
Okay. Mr. Garcia, how long do you need to get an order back to me?
It depends. If you want the parties to sign it, I probably need a week. If not, I can e-file it today.
Okay, a week is fine to, and I would like for them to sign it since it is an agreement.
Okay.
Let me see if Odyssey just crashed on me. So let me see if I'm able to get a date for you. So you said a week. What about Halloween? Or you need the following week?
It just depends how quickly they can docu-sign the order and get it back to me. So it's, I mean, really on them. Because the order's prepared. I just need to get it to them.
All right. I give you all some more time because I know emails, things go to junk all the time. So
Right.
let's do November 7th.
Okay.
I'll make that your entry day. And so Ms. Muhammad and Mr. Muhammad, on that day, that is a setting just in case the order is not signed, where you all will have to come and appear in front of my associate judge on Zoom. However, if the order is circulated and signed before that day, Mr. Garcia would just send the completed order. I'll sign it and get it back to you all, and you can disregard that date. You don't have to show up on Zoom. Does that make sense?
Yes, ma'am.
All right.
Judge, do you want me to e-file it and then get it to?
It'll be easier if you send it directly to Brittany.
Okay, will do.
All right.
Are we excused?
Yes, you're excused. Thank you so much.
Thanks. Bye, everyone.
Thank
Bye-bye.
you.
Hold on one second. Let me see if I can add this because Zoom just went down on me. It literally just froze on me again. Yeah. I needed to enter those dates. I made notes of them, so it's fine. Did you all have an opportunity to speak?
Yes, Your Honor.
All right. Is there an agreement between the parties?
I think there is, Your Honor.
All right. So Joey, are you ready? All right. And I swore you all in, right? Or did I?
You want me to tell the court what the agreement is?
Yes.
No, okay, I did. In 1 second, I'm trying to remember if I swore the parties
I
in.
see.
I don't think I did.
No, ma'am.
Okay, thank you, Mr. Reyes. Joey, let me know when you're ready. All right, we're on the record in cause number DF 15053996. Counsel, will you please announce for the record?
My name is Jerry Melton. I represent Maria Ramirez.
Okay,
Michael Reyes.
Michael Reyes, and sir, you are the respondent in this case, is that correct?
Yes, ma'am.
And you're representing yourself?
Yes, ma'am.
Okay, would you all stand and raise your right hands? I need to swear you in. Ma'am, you too, yes. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
Thank you. You all may be seated. We're here today on a motion for enforcement. Subsequent to a motion for enforcement, a motion to revoke the suspended commitment was filed today, but it has come to the court's attention that there is an agreement between the parties. Is that correct?
That's right, Your
Yes,
Honor.
ma'am.
Okay, counsel, would you go ahead and read the agreement between the parties into the record?
Well, okay, so the parties have agreed that the movement will waive the amount of past due child support, and that Mr. Reyes will continue to make his current medical support payments and past due medical support payments as ordered. We have agreed further that Mr. Reyes he currently still owes the amount of $2,700 for attorney's fees to me, and he will pay that amount of attorney's fees to me by the end of December this year. So December 31, 2025. And then he owes to me now additional attorney's fees for having to deal with matters from last December until today. We have agreed to settle that amount for $5,000. And he will pay that amount to me, the amount of $5,000 by the end of June of 2026. And so to be clear, the amount of $5,000 will be paid to me then for, shall we say, current attorney's fees and expenses by Mr. Reyes by June 30 of 2026. And that's basically the agreement that the parties have come to this morning.
Okay. All right. And Mr. Reyes, you just heard the testimony about the agreement. Is that correct?
Yes, ma'am.
Is that your agreement?
Yes, ma'am.
All right. Ma'am, is that your agreement? Yes, ma'am. He said that in the beginning. Yes, thank you. And thank you all for working that out. Counsel, would 2 weeks be enough for you to get the order circulated and signed?
Yeah, I think that should be enough time, Your Honor. I'll let you know if there's any issue with that, but I think it should be. And I didn't know if you might want to reschedule a hearing regarding this matter to sometime like in July of next year, or just wait and see if the order's followed, or how you might want to proceed.
Because you all came to an agreement, I'm going to give Mr. Reyes an opportunity to abide by the agreement while also following the court order. So I'm going to just put you all on a dismissal docket and let that order work sometime. Now, Mr. Reyes, you understand that you have to follow the court order,
Yes,
okay?
ma'am.
And it's going to look even worse if she has to come back in here on a motion to revoke an agreement because this is something you agreed to,
Yes,
okay?
ma'am.
It's
Yes,
not anything imposed by me under the law. This is your agreement.
Yes, ma'am.
So follow it,
Yes,
okay?
ma'am.
Well, if it's not too much trouble, Your Honor, could we set it maybe for sometime, say, next July? And then if the agreement is followed, I'd simply send an email and cancel the agreement. I mean, the hearing date.
No, I don't want to do it like that. I want to give him an opportunity because
Okay.
if I do it that way, and I'm not saying you're going to do this, Mr.
Yes, ma'am.
Reyes, but you have to understand from where I'm sitting.
Yes, ma'am.
If I do it that way, more than likely you'll do what you're supposed to do. If I don't have any lens or anything on you monitoring you, that'll tell me if you're really going to do the right
Some
thing.
kind of pressure on me.
You see what I mean?
Yes, ma'am, I understand.
So I would rather see that you're going to do the right thing without me having to supervise in a sense. Because if I let this case stay open till July, that's exactly what I'll be doing. I'll be supervising you. So I want to give you the opportunity to do it on your own.
Okay.
Okay?
Thank you.
All right. So I put you all on the dismissal docket for November 7th, 2025 at 9:30 a.m. And that'll be in front of Judge Lee.
Well, could it be via Zoom, Your Honor, instead of
Yes.
in person?
Yes, on Zoom. Yes, yes. So let me give you all the Zoom code.
I mean, I don't think we'll even need the hearing in November, but just in case, it could be via Zoom if there are any issues.
Yes, it will be via Zoom. So the Zoom code is 961 1106 4392. And let me know if you need me to repeat it.
Yes, ma'am, can you repeat again, ma'am?
Just a minute, Your Honor.
Sure.
Toby, you need something to write on or? Hang on just a second, Your Honor.
No problem.
Let me get I think I have well, here, wait, I'll tell you what we can do. Just a second. We're not gonna need this either, but you need a pen. Okay, there we go. Now we got it.
Okay. 961 1106 4392.
Okay, good.
All right. So, and that'll be in front of Judge Lee, just in case you need it. You may not need it.
Okay, yeah, that's fine.
All right. Well, thank you all.
Thank you, Judge.
Well, thank you,
You're welcome.
Judge, for
Have
your
a good
time
day.
today.
You too, thank you.
You're welcome. Yes.
Amanda Smith is.
Hi. How are you? Okay.
Here's your.
Good morning. And I
Thank you.
see Mr. Kincaid. He's on Zoom. Okay. Okay. Is your attorney Ms. Hernandez?
That is my attorney.
Good morning,
ma'am.
Your Honor. Yeah, I'm here for Drew Kincaid.
Okay, got it. Okay, so Attorney McKnight is not representing you. Okay. All right, give me 1 second. I'll be with you all in just a few minutes.
Thank you.
You're welcome.
Yes, ma'am.
All right, and ma'am, just make sure you pull the microphone that's there, pull it all the way up to you. Yes, there you go. Okay, good morning to everyone.
Good morning, Your Honor.
Morning.
Morning. All right, so um, let's see. All right, so we're here on a contempt enforcement motion. However, I don't see any exhibits from either side.
Well, first, Your Honor, we're not seeking contempt, so I just want to make that clear. That's not something we're seeking. It's not in our petition or in our order. Number two, we did have a status conference with Judge Lee last week, and myself and Ms. Smith both sent exhibits to Judge Lee.
Okay, she didn't send over, and I spoke to Judge Lee. She said that you all never, you discussed some exhibits back and forth and you objected to some exhibits, but she never received any exhibits to finalize what the admitted exhibits were.
Oh, I thought we had reached an agreement on exhibits, and then Judge Lee had said that hers, Ms. Smith's exhibits that I was objecting to were admitted, and that you could make the determination based on my objections, but we
Did you
did
all
send
send
them.
her
Would you like?
email?
Yes,
Oh.
ma'am.
She needs to, what she would have needed is an email with all of, or both of your exhibits
Yes.
that you agreed to. Because without exhibits, I can't move forward. Well, I mean, we can move forward, you just can't use exhibits.
I'm glad to move forward today, Your Honor.
Okay.
Well, we want to move forward as well, but I'm happy to resend the exhibits. I saw Ms. Smith's exhibits come through. I saw mine come through, and we told Judge Lee on the Zoom which ones we were okay with.
Okay, well, before you even do all that, your client, Mr. Kincaid, he's the moving, correct?
Correct.
All right, and this is an enforcement, let me make sure I'm looking at the violations correctly. It's 6 violations, right?
Yes.
And you're not trying to hold her in contempt. So you just want, what is it that you're asking the court to do? Because I'm not clear from your motion.
Yes, ma'am. So we're not asking for contempt. I don't believe we have anything under the family code that allows for contempt, but we do have some items that need to be returned. We've got some funds that were misused that need to be repaid to Mr. Kincaid. And then there is a Jeep Grand Cherokee that needs to be transferred. The title needs to be transferred into solely Ms. Smith's name. That still hasn't been done. And then really just an admonishment to follow the order that she agreed to.
Okay, the power of attorney, do you have it?
No, ma'am. Ms. McKnight is not my lawyer anymore.
Okay.
And I feel as she just hasn't represented me since we came to the settlement agreement. If Mr. Kincaid would simply give me the title per your order, I will take care of that immediately. All he has to do is hand it to me.
And counsel, the reason I was asking about what it was that you wanted the court to do, because your motion is not even specific enough for me to find that she even violated the order. For example, violation 2 reads, mother has violated the order by consistently being late for possession exchange times without notice to father. That doesn't put her on adequate notice pursuant to the slaughter case about what she's supposed to do.
I think there, Your Honor, we're just looking for an admonishment on going forward to please be on time with possession.
I'm not exactly aware of the dates and times they're speaking of.
Yeah, and that's another thing and thank you for saying that. Pursuant to Slavin, it has to allege date, time, manner. None of that is in here.
Okay, that's fine for the late times because we're not looking for any actual relief on that other than both parents need to be on time. So if we want to move forward without that one, we're happy to do that.
Okay, Well, counsel, you're. Mm.
In the prayer, Your Honor, it does say what we would like to have done.
I understand, but before we even get to the prayer, we have to get through your violations and your violations.
May I speak to?
Hold on one second.
Yes, ma'am.
I don't even know how you would get there.
I'm
Your
not,
violations are not even sufficient to put her on notice for the court to even grant what you're asking me to do. Does that
in
make
which
sense?
way other than number 2?
Well, I can't tell you that. I just can tell you by looking at it, is really going to be hard for the court to find her in violation when they're not specific enough to put her on notice. Have you all had an opportunity to discuss coming to any type of an agreement regarding the motion?
I have tried many times, and I know that Mr. Kincaid has tried many times to settle this matter with her. I've not received any response to our settlement offers, and I don't know if Mr. Kincaid has, but I know that it hasn't gotten anywhere.
Your Honor.
Okay, go ahead.
I have not.
In my defense.
Well, you don't know.
Well, this settlement offer is adding so much more to these violations. I am at the mercy of the court right now because he literally wants so much more than what they are bringing me here today for. So no, I am not going to agree to a settlement to get rid of these items. And it just, the settlement agreement is beyond these violations.
Okay, you all both understand that an enforcement only allows me to enforce what has already been ordered, right?
Yes, Your Honor. The problem is that's the first I'm hearing of that. Up until this point, I've had no idea what she's not okay with. So the discussions, to answer your question, no, there's not been a discussion
That's
because
exactly
we've just
what
sent
I am.
offers.
You all can't talk over each other. This what I'll do. Okay, I will allow you all, if there's a conference room back there, if you would join the Zoom, I can put you all in a breakout room. That way, because the counsel, she just said this is her first time hearing it. Now, you may have had conversations with Mr. Kincaid. I don't know if it was probably translated to him, to his attorney, the proper way.
Right, well, I just refuse.
Okay, so even after her saying that
Yes.
this was her first time hearing you say that, you're still refusing?
There have been plenty of communication.
No, it's a yes or no. Are you still refusing after
Yes.
what she just said?
Absolutely.
Okay. Joey?
Your Honor, if I may, I would like to talk to her about what we could do to resolve this. I really would. I haven't had the opportunity to talk to her.
I would like the opportunity to not have discussions with them anymore and focus on the violations at hand.
Okay. All right. So counsel, you heard that?
I did hear that, but that is what the settlement discussion would be about, is how to resolve the violations in front of the court today.
If I can speak to the violations, I think that we can agree. And Your Honor, my suggestions, I do think moving forward would be somewhat of a resolution.
Okay. So could you do this for me?
Yes.
Right? Could you speak to counsel? And it'll just be you and her in the breakout room.
Mhm.
Okay. Could you speak to counsel specifically on addressing these violations?
Mhm.
Anything else, you all can table that for right now. I just
Exactly.
want you all to speak to these violations. And I'm not trying to force anyone out of having a hearing, right?
Yeah.
I don't want either of you to think that that's what I'm trying to do. However, I do believe that as best you all can work together on a settlement, it just makes it better for everyone versus me telling you to do something, then you're mad because you really don't want to do what I told you to do. You'll, at least if there's an agreement, you're more inclined to follow it if you all agree to it. Does that make sense?
It does make sense, Your Honor.
Okay, so you have the Zoom app on your phone?
I do.
Okay, so let me give you the Zoom code so you can join, and then there's a conference room. It's 2 conference rooms. You can go in either one of those and go on the Zoom, and I will add you to this breakout room.
Yes, ma'am.
Let me see. And Mr. Kincaid, you're just gonna hang out here with me, okay?
Yes, Your Honor. Appreciate it.
No problem. So, counsel, I'm inviting you to room 2. As soon as Ms. Smith joins, I'll add you over too.
Okay. I do believe I have Zoom.
All right. Are you all here on the Smith case? Oh, okay. I see everybody's here. Crystal and Samuel are here.
The meeting ID.
Oh, I'm sorry. No, you're okay. The meeting ID is 688-044-0164. And you should be able to see yourself pop up.
I do.
Okay.
And join.
All right. And I'm going to rename you so I don't call you iPhone, okay?
Okay, thank you. Yeah, just right here.
Amanda. Thank you, Ms. Smith. All right. Let me move her. All right. So both sides ready? Okay, you all can go ahead and set up at the council's table. Crystal Smith will, who is your client attorney? Yes, Crystal Smith, you'll sit right here. I remember you all. It's a reset, right?
Yes.
Okay, okay. And I have exhibits. Let's see, judgment of absolute divorce and a Maryland settlement agreement. And then I have exhibits. Is this 1 through 4 on respondent?
We don't have.
I mean, are these you?
There are two orders, Your Honor. One is a absolute judgment, and another one is a settlement agreement.
Okay, never mind on the other one. That was another case.
Oh, okay.
I was kidding.
Okay.
Okay, so I just have the judgment of absolute divorce and a Maryland settlement agreement.
Yes, those are the two.
Okay. All right. Are there any preliminary matters that the court needs to take up first?
Yes. Oh, sorry, we just need you to go ahead. You can go first.
Your Honor, we're just asking for a dismissal. The pleading state.
Hold on 1 second. Do you want this on the record?
Sure.
Okay. We're on the record in cause number DF 2304385. Councils, will you please announce for the record?
Heather Nicole Johnson for the movement, Christelle Smith.
Anna Nika for Samuel Smith.
All right, with those who intend to testify, please stand and raise your right hands. Do you both swear or affirm that the testimony you'll give will be the truth and the whole truth? Thank you. You may be seated. All right. Prior to going on the record, the court asked about any preliminary matters that needed to be taken up. And Attorney Nika, I believe you had the floor.
Yes, the pleadings cite the marital settlement agreement, which is not a portion of, which has been quoted as what's been violated. And the marital settlement agreement is not incorporated into the judgment that has been registered as the foreign judgment in this court. So therefore, it's a motion on no judgment, in our opinion. There are no instructions for determining if there's a valid cause, the date and time of reimbursement, method of reimbursement. None of that is in the order. In addition, according to 157.002A2, which you mentioned before in Slavin, it has to state the manner of the respondent's non-compliance. This is a motion for enforcement of payment of extracurricular activity fees and for unreimbursed medical expenses. And there is nothing in the pleadings that it just says the date and amount due. It doesn't state any identifying information about what is due and what it's for. So therefore, we have no way to prepare for violations. My client doesn't have clear notice on what $111 on March 30th is for, and or to either defend the lawsuit or to be able to even comply with their request. So we're asking for a dismissal, or, you know, and then the other argument we have is for clarification, because the order itself is ambiguous. It's ambiguous when it's reasonably susceptible to more than one meaning, obviously. They don't define what an extracurricular activity is. Is this a school-sponsored event? Is this dance classes that anybody can sign the kid up for? Is this agreed to or not agreed to? And also the health, the specific order, which is not cited here, but just for the court's reference, it states, father and mother will discuss major issues and make these decisions together. And it specifically talks about elective surgery, education, general health and safety issues. And then later on it says, mother has tie-breaking authority, which basically gives her the exclusive right.
Hold on, counsel, where are you reading from?
This is page 3 of the judgment of absolute divorce.
Okay.
I'm sorry, it's page 3 of the parenting plan agreement, which is an attachment to the absolute divorce.
All right, hold on one second, Okay, the judgment of absolute divorce that I see is just 2 pages long.
That's true. Then there's a parenting plan agreement, which is attached and incorporated into the judgment.
I'm not seeing that with the exhibit. Counsel, the exhibits that you sent only has those 2 pages.
So there is an incorporation. I'm trying to open mine as well, Your Honor. Give me 1 second.
The original filing has the registered judgment.
Yeah, and that's the motion for enforcement?
No, the original filing in this case
Oh, okay.
is the registration of the foreign judgment, which doesn't include the marital settlement agreement. The judgment is just based on that agreement, like an MSA.
What is the date that you're looking at on that?
This is from,
The registration of the foreign judgment?
oh, it's from 2023. I don't know it's the original filing in this case.
All right, I think I found it. Okay, page 3. I have it.
At the parenting plan, page 3, it says it's under G.A. Decision-making, major decisions. So it's not clear who gets to make these decisions. And then we're trying to enforce payments for elective surgeries, elective therapy, and several elective options as well. We think, we can't tell from what these charges are from the pleadings, but we think they're elective, and we don't know who gets to make those decisions. So if not dismissed, it at least just needs to be clarified rather than an enforcement proceeding.
Thank you, counsel. Response?
Yes, Your Honor. Well, for starters, with respect to what is clarified or on its face on the motion, if we go to page 2 and page 3, the actual language from, and I will concede that these orders, since they're from another state, are quite different than what we're used to seeing. But the language that is used in the order is all that the party had to work with. So that is included, and it specifies exactly what Mr. Smith's obligation was, under which particular order and document that under which it was rendered for him to comply with that obligation. It specifies what was health insurance, even in beginning on page 3, section 8. It states that this list going through, or for these particular violations, are all for the extracurricular activities. The next set of violations, all of these are for healthcare expenses. And then so it's broken up into 2 sections. So it's very clear on its face and gives sufficient notice to the respondent as to the purpose that for each one of these expenses that my client submitted to him, as she was obligated to do if she wanted to be reimbursed. Also, with respect to the manner in which he failed to make the payment. Specifically, the controlling order under which we are seeking the contempt finding, there is no specified manner by which he was supposed to do any of that. So we can't create one just for the sake of the motion. Further, I am in agreement. A clarification by this court would be fantastic because it would be, it would clarify from, I guess you could say from a Texas litigation standpoint, the way we do things here, what this order needs to look like. But all in all, that does not change the fact that he failed to comply. So we do ask the court to proceed on hearing these particular alleged violations by Mrs. Smith of these expenses that she has not been reimbursed for by Mr. Smith. And also, if the court does find any language that needs to be clarified, we are totally in favor of that, Your Honor. And also, I believe there was an issue. Your Honor, with respect to the Maryland order here from Prince George's County, that particular judgment and settlement agreement are do appear in the minutes of the court. It has been filed with the clerks of the court.
I'm looking at the marital settlement agreement. Is this the one that is 13 pages long?
Yes, Your Honor.
So that was incorporated into the absolute judgment?
Yes, Your Honor.
I didn't see it. I read the absolute judgment. I did not see it incorporated in there, and we did not, when we registered the foreign judgment, did not include it. So therefore, it's not a Texas order because it hasn't been part of the registered foreign judgment. And that's the part that says reimburse wife within 15 days of receipt. The actual absolute judgment doesn't have any of that language.
So whoever drafted the order in Maryland just didn't bring the language over, right?
That's what it sounds like.
Yeah, okay. The court can clarify an order and without making substantive changes. So the manner, like the 15-day, because you all have to be able to, he has to be on notice. He has to be able to follow it. So the court can clarify some things. Now, some things I can't do because it'll make a substantive change to the underlying order. So let me just make sure I'm clear. The issues are the failure to reimburse extracurricular activities and health insurance reimbursement.
Yes, Your Honor.
Okay. And counsel, what you're saying is that your client is not on notice.
Right. We don't know what any of these charges are for. I mean, what extracurricular activity was $1,500? I mean, I don't, and is that something that needs to be agreed to, extracurricular activities, if they're that much money?
You're saying the total?
Correct.
Okay.
On page 3 of the motion, March 5th, 2024, there's a bunch of charges adding up to about, I don't know, $1,600, $1,700. I mean, but it's not identified in this pleading as to what that was for, so we don't even know if it's a legitimate.
Well, Your Honor, by virtue of the evidence and my client's testimony, we can demonstrate what these expenses are for. She provided or submitted receipts to him at the time for the expenses, which clarified what they were for.
We don't have any of the receipts and they're not exhibits, so I don't know how that's gonna be shown.
Your client just going to testify to what she paid? Because I don't have any exhibits with the receipts.
She can testify as to what she paid, Your Honor, as well as what the reason for those expenses.
Okay.
Yes.
So the court is going to deny the request to dismiss the case. The court, if after hearing testimony, the court decides that a clarification will be done, I will tell you all how we're going to clarify it. But I do need to hear testimony from the both of them to be able to make that decision. So, we're gonna proceed with the hearing. You all have 15 minutes aside. Are there any other preliminary matters that the court needs to take up? Okay.
Not at this time for much.
Okay. All right. At this time, is anyone asking to invoke the rule?
No.
Okay, counsel, attorney, because both of you are counsels, Attorney Johnson, you may call your first witness.
Honor, I would like to call Samuel Maxwell Smith.
All right. Sir, if you just come sit in this seat here and make sure the microphone is pulled as close to your mouth as possible.
Thank you. May I bring on?
What's on it?
You could take a blank one, but
Yes, a blank one, yes.
Right.
Okay. Right? Counsel, you may proceed.
15 minutes.
Yes.
Mr. Smith, can you state your name for the court?
Samuel Maxwell Smith.
And you were a party in the Maryland divorce case in 2020, correct?
Yes.
Just make sure you speak directly into the microphone. There you go.
Yes, Your Honor.
And that judgment from that case, it was a judgment of absolute divorce, included a marital settlement agreement, right?
Yes.
And you signed that agreement voluntarily, correct?
Yes.
You understood that it required you to reimburse my client within 15 days of receiving receipts, correct?
Yes.
And you were,
we would like to object, and we were asking for another motion to dismiss. In this case, this is obviously a quasi criminal proceeding. I'm assuming they're going forward on the petitioner's second amended motion for enforcement of child support order. We are served with an order to appear that said, that is ordered to appear for a motion for enforcement of the child support order, not a second amended motion for a child support order. So we're asking that this case be dismissed for not enough notice and for my client's due process rights. The order must state with clarity, specifically and unambiguously, and we were not properly noticed of the hearing on the order to appear. We're asking that double jeopardy attached.
Okay, response.
Honor, he has already taken the stand. He has already begun answering questions. And the court gave us an opportunity to put on or to present any defenses before this hearing begun, and counsel did not subscribe. Now, with respect to double jeopardy attaching, there was never any service on Mr. Smith until the time between the last time we were here and today. That is the only reason we've been able to go forward. It's not as though he's been sworn in to reappear. So the proceedings did not actually begin until today.
I remember he wasn't here the last time.
No, he was not. He had not been served.
We had agreed to reset it because he couldn't get here because he flew in from Maryland for the hearing and he couldn't get to the last one. So we agreed to a reset. They filed and served him with another order to appear and the second amended motion for enforcement. The order to appear states where to appear for a motion for enforcement. They served us with a second amended motion for enforcement. So I don't know which one we're here for today.
Well, Your Honor, even if we're on the original, it doesn't change my line of questioning.
So the second amended motion was filed on March 11, 2025. correct?
That sounds about right, Your Honor, yes.
All right, and then we had a contempt hearing in May. Let me just go back through my notes. All right, so there was a contempt hearing that was set in May, and then we had it reset. Okay, those are petitions to modify. So specifically on the enforcement, we agreed to a reset date, which is today.
And then he was served again with an order to appear in the second amended motion. The order to appear does not notify him that it's on the second amended motion. It notifies him of a motion for enforcement. They've started the case on the second amended motion for enforcement. We're asking that it be dismissed for not proper notice.
Okay, so after we agreed to reset, you all amended the motion?
They served him with another order to appear for today's hearing.
I guess where the disconnect is, he was served to be here. We agreed to reset it today on the second motion for enforcement.
He set the hearing, which was notice for motion for enforcement the first time.
Okay, so not the second motion.
So then, after we reset it, they filed another order to appear and served him with that order to appear, which also said motion for enforcement. None of the order to appears have ever said second amended motion for enforcement, even though it's been on file.
Right, I get that. However, we reset it on the second amended motion.
I don't know what we were saying. We were here for the motion for enforcement for that hearing.
No, it's clear. We reset it for the second amended motion to appear.
But what I'm saying is the order to appear doesn't say it's for the second amended motion. And for a quasi-criminal case, it has to be a very clear notice of what case we're here on and whether it's the second amended or on either it's the motion for enforcement. They've already started on the second amended, so we're asking that it be dismissed because he didn't have proper notice that it was the second amended and not the motion for enforcement, which is what the order to appear says.
Well, I can't put him in jail anyway. This is for extracurriculars and health insurance. This is not child support. So, I mean, are you all removing the contempt? Because you can do, I mean, it's disingenuous to show up today for a second amendment and say, hey, they did this order to appear subsequent of that when I reset it based on availability. I think that argument is very disingenuous because, and I'm not saying that mistakes don't happen and the order to appear didn't say whatever it needs to say, but I reset it. The court reset it, and I said it on good faith grounds that you all needed more time. So to come in here today and say, hey, we want to dismiss this case after we agreed to reset it today, I don't believe that's fair to either one of them.
Well, we just didn't have time to have reviewed it by that.
Yeah, counsel, no. I reset it. The court reset it. You all didn't reset it. I did. So how do I go back on something that I did in good faith based on what you all told me you needed?
We're saying that the second order to appear didn't identify what this hearing was for, so it was unclear. Even if we reset it for the second amended motion, the order to appear says regular motion for enforcement.
Well, even if, honestly, I don't know why an order to reappear was even sent. Maybe that's just habit.
I think
based
to be out, Your Honor.
Or maybe, or it could have been. I don't necessarily know. All I know is that you all came in front of me. We went on the record and we reset it based on the second amended motion. I remember it vividly because I remember your client being upset that we had to reset it. I remember it vividly. That's the only reason why I reset it. And I made it clear that the next time that we came on the second amendment, amended motion, that we would proceed.
I don't recall it being clear on which motion we were going to proceed on, but that I could easily be wrong.
Yeah, it was the second amended motion because that was their second time coming to court. I remember it vividly because when they walked in, I said, oh, I remember the parties. And I remember resetting it on that day for the second amended. Like I said, while the order to appear was filed, I'm not gonna hold that against any attorney because I know habit. But according to the court's docket, we are here for the second amended motion, and that's what was reset back in May.
And I understand that, all I'm saying, all I was pointing out was that, never mind.
Okay,
Just pointing that out because it wasn't clear to me.
okay. Well, I think the record is clear.
Okay.
And yeah, so I did say that he can't go to jail anyway. Like, sir, I can't legally put you in jail, okay, for failing to pay extracurricular activities. I'm not allowed to do that by statute, okay?
Yes, Your Honor.
Okay. All right, counsel, you may proceed.
Thank you, Your Honor. I believe where I left off. Oh, Mr. Smith, I was asking you whether or not you understood that the agreement required you to reimburse my client within 15 days of receiving receipts from her.
Your Honor, we object. The marital agreement that may or may not have any requirements is not part of the order of the court.
Sustain. Just so we're clear, the court is proceeding based on the foreign judgment that is registered, which is the judgment of absolute divorce.
Thank you, Your Honor. Mr. Smith, prior to today, you haven't alleged that the order is unclear, correct?
I have, is there any way you can repeat that, please, or rephrase?
Means that this order is unclear, correct?
That is incorrect. The Maryland order was extremely ambiguous, which was one of the reasons I wanted to bring it here to Texas so that we could get some more clarity, because I felt like it was being used unilaterally.
So when did you file your motion or petition to have the order clarified?
I'm not certain exactly. Could you rephrase it so I could understand a little bit?
When did you file a petition asking this court to clarify the order or the judgment?
The clarification was just when we were in Maryland.
No, I just want to know, when did you file for a clarification in this court?
I don't have the date at the.
But your testimony is that you have filed for a clarification?
No, that's not what I was.
1 second. Sustain, rephrase.
Mr. Smith, my client sent you receipts for the kids' extracurricular expenses, correct?
There were some sent, yes.
And she also sent you some receipts for their medical expenses as well, correct?
There were some sent, yes.
And those receipts included like medical copays for the boys, right?
In some of them, I can remember, yes.
Okay. And some of the activities were for their extracurriculars outside of school, correct?
Correct.
And you didn't reimburse her within the 15 days, correct?
Judge, it calls for a legal it's restating an order that's not an order.
Well, we can't read from it. However, he did admit in the beginning. Let me scroll back. Okay, course apologies, sustain.
Mr. Smith, you've had an opportunity to review the motion that we're here on today.
I have had an opportunity to look over the paperwork, yes.
Okay. You would agree that you didn't pay any of the amounts that are listed in that motion, in this motion, correct?
Any of the amounts for
The extracurricular activities.
extracurricular activities, not to my knowledge.
You didn't pay any of the amounts for the medical expenses either, correct?
Not to my knowledge.
And you didn't dispute those expenses when my client sent them to you, did you?
They are in heavy dispute.
How did you dispute them?
I have emails, I have text messages for a long time asking to clarify, because many of these extracurricular activities, I declined them at the beginning of the year.
And your all of the things you've done to, did you bring that with you today?
They've been sent to my attorney. I could produce them in a moment.
Okay, can you go ahead and get them for me?
Sure. Would you like?
Oh, they're in your phone? They're not actual documents that you brought with you to court today?
If I can produce them,
No, I'm asking, did you physically print them off and bring them with you to court?
they're not physically printed, no.
Fine. So prior to today, you didn't ask the court. We already explained this or discussed this, but I'll just ask you one more time. You didn't ask the court for clarification before the motion for enforcement was filed by my client, correct?
I'm not sure what that means. Clarification on.
You stated earlier that you did not believe that the order was clear and that you wanted it clarified in the Texas courts. Wasn't that your testimony moments ago?
What I was speaking to moments ago is that when
Hold on one second. Let me streamline this because I don't want either attorney to run out of time. You didn't answer her question. Her question was, she said you stated earlier that you did not believe the order was clear and that you wanted it clarified in the Texas courts. Wasn't that your testimony moments ago? It's a yes or no.
I do want it clarified. Did I share with the court?
No, yes or no. You wanted, she restated what you said. So she said you stated earlier that you did not believe that the order was clear and that you wanted it clarified in the Texas courts. Wasn't that your testimony moments ago?
I did want everything that was not clear in Maryland because they write very loosely. I wanted everything to be handled here.
Okay, so the answer to her question would be yes then.
Yes.
Okay.
Thank you. Sorry.
You're welcome. No problem.
Thank you, Your Honor. And so just so we're clear, your share of the expenses was to be 73.9%, right?
Your Honor, we have checked, the pleadings don't have that portion of the order quoted as part of the portion that was violated.
I'm looking on page 3, number 8.
Correct. So where she quotes the order that was violated is on page 2, number 6 and number 7, which doesn't include anything about the proportional share amount. Proportional share amount. About the what? Proportional share amount.
So when I'm you're talking about referencing the underlying order? I'm looking at it on page 2, number 7. It says on October 13, 2020, in cause number CAD 20-06064, styled Crystal K. Smith, plaintiff v. Samuel M. Smith, defendant in the Circuit Court of Prince George's County, Maryland. The court signed a judgment of absolute divorce that appears in the minutes of the court and incorporates document style marital settlement agreement and parenting plan agreement. The 255th Judicial District Court of Dallas County, Texas has adopted the judgment to be a Texas order, and the aforementioned parts state this.
Right, and what she says, where she quotes what it says, it does not include the amount of the proportional share, which is
I see 73%.
It's on number 8, but it's not quoted as part of the, I'm just saying it's the fact, that's all.
Your Honor, it is included in paragraph 8 prior to the listing of the allegations. It states what we're alleging for the violating the orders described above.
Yeah, counsel, I see it. It is there.
I'm just saying it's not quoted as part of the order. It's mentioned later on that it should be this amount, but it's not quoted. That's all I'm saying.
Okay, overruled. Counsel, you may continue.
Thank you, Your Honor. So, Mr. Smith, according to the order that the orders that we're discussing, your share was 73.9%, correct?
May I speak to that briefly?
No, sir.
Your Honor?
You cannot, hold on one second. You cannot. You have to answer the questions that are asked. Now, if your attorney needs you to clarify something, she will then ask you. Just do yes or no.
Yes.
It was 73.9%, correct?
Yes.
And you understand ultimately that my client was covering your share and her share.
No.
As of today, you've paid nothing towards these amounts, correct?
Towards which amount? Since when?
Listed in the motion, you've not paid any of these amounts.
No.
Correct, thank you. And you're not saying that my client refused your reimbursement, correct?
No.
You're not saying that she failed to send you any receipts, correct?
I'm not certain if I got all the receipts.
But
I'm
you
not.
know that she did not. You're not here today alleging that she failed to send you any, correct?
Correct.
Okay. And prior to today, until today, you never asked for clarification of these underlying orders, correct?
I am interested. Could you rephrase, please? Because
The question was prior to today and until today, you never asked for clarification of these underlying orders. Is that correct?
ask for clarification from the court or from directly to Ms. Smith, or where?
Let's go with both. Have you asked Ms. Smith to clarify the orders?
I asked Ms. Smith to clarify
Just want to know yes or no.
the orders. That's
It's a yes or no, sir.
I asked Ms. Smith to clarify the 73%.
Okay. And when did you ask the court to clarify the orders?
The 73% was based on.
When did you ask the court to clarify the orders that we're here on today? When did you ask the Texas courts to do that?
The clarification meant transferring it here to Texas.
The question was when. So a date or a time.
Modification.
Okay, so according to what your attorney just said, do you understand the difference between a clarification and a modification?
Not completely.
Okay.
Your Honor.
Counsel, you can rephrase or you can move on.
I'm gonna move on, Your Honor. So Mr. Smith, the only reason that you didn't pay these obligations is because you chose not to, correct?
That is incorrect.
So you didn't seek clarification prior to today, correct? You just testified to that. You testified that you did in fact receive my client's
It's
receipt.
incorrect. I tried to get clarification.
Be allowed to finish my question?
Go ahead.
You testified moments ago that you did in fact receive the receipts from my client.
Objection, that's a mistake.
And
Sustain, rephrase.
okay. Are you here today alleging that my client failed to give you any receipts notifying you of these obligations?
I'm not sure if all the receipts were sent, but whatever she sent was sent. So how do I?
Today that any of the dollar amounts listed in the motion that she did not send you receipts for any of these expenses listed in this motion?
I'm not saying that.
Okay,
No.
so you're not saying that. You're not saying that you didn't understand that you were to pay 73.9%, correct?
Correct.
Okay. So then the only option that would leave us with is that you didn't pay because you chose not to.
Is
Is
incorrect.
true, Mr. Smith?
That there are other extenuating circumstances that I cannot.
Second, hold on 1 second. Wait for the next question. Go ahead.
Are you alleging financial hardship?
No, I'm not alleged. On whose behalf? Mine?
So if you are not alleging financial hardship, you received the receipts that you just confirmed you received from my client.
I apologize. What is financial hardship?
1 second. Hold on 1 second. Sustain. Next question.
Thank you. What is the reason that you did not comply with the court's orders?
Which orders are you referring to? The 73%?
I'm referring to the orders that we're here on for today that were listed in this motion.
There were multiple reasons. May I list some?
I mean, she asked you, what were the reasons?
Yes, ma'am. Yes, Your Honor. Apologies. There are several reasons. The initial, this was part of our custody hearing, whereas the 73.9% was based on a number during the divorce in 2020 when Ms. Smith was a stay-at-home mom. She had shared that she had employment, and I asked, can we get it updated? So that the percentage would be accurate. Then I found out she was working for a Fortune 500 company. So the 73.9%
A second.
was based, sorry.
I have to sustain it, but counsel, you asked him an open-ended question.
I have more.
I do
Hold on.
clarify that he's testifying beyond the scope of.
Okay, sustain to that. So anything prior to the order, you can't answer. You can't respond to that because it's not relevant to what happened after the order. So anything that happened prior to the order, any agreements that went into the finalization of the order is not relevant. So anything that's relevant is from the date that the order was entered, which I believe was 2020. That day to current. Does that make sense?
Help me just a little bit. Sorry, this is my education. So things that happened in 2024, would they matter? 2020, yeah, this is what.
After 2024.
Right.
So like you were mentioning about the her being a stay-at-home mom and everything like that, those things wouldn't be relevant.
Understood. Thank you.
Okay, so counsel, did you need him to continue with the reasons?
No, Your Honor, I don't.
Okay.
May I continue?
No. You have to wait on the next question.
Yes, Your Honor.
Just so we're clear, Mr. Smith, you've known at least since March 11, 2025, that these reimbursements were owed, correct?
Correct.
And even after.
Which ones? I'm sorry. Before. I would like to read them again, but I would say yes.
Okay, let's go with yes. And even after being served, you still haven't paid them, right?
No, they were part of our custody hearing that got brought into this one.
Sustain.
Yeah.
Like I stated, sir, you're the client. Your attorney will clarify anything that you stated, and that's being asked, okay?
Yes, Your Honor.
Okay.
Mr. Smith, you understand that failure to comply with a court order is contempt, correct?
I'm learning how the system works. I don't know. Could you clarify some of that, please?
You do understand that when a person fails to comply with a court order, that is contempt?
In this case, I think it's ambiguous because,
Sustain.
okay,
You did not comply with the court order in this case, correct?
I'm not certain if I did or not.
Did you bring any evidence with you today to show that you did?
I have documents whenever my attorney gets to ask me. I don't know if it was submitted for today. We would have to.
Counsel, you have 2 minutes and 36 seconds.
That's the witness, Your Honor.
Okay.
Thank you.
Attorney Nika, you're welcome.
Mr. Smith, on January 23rd, 2024, did you receive a receipt for $142.58?
Yes,
What was that receipt for?
I'm not sure.
So are you saying you received receipts for all of these charges?
There were some receipts that were sent via the parenting app. We had started using. Was that the time we had started using the parenting app yet? I think we were given a parenting app. Either was that or a text message. I'm trying to recall.
Did the receipt say what the charges were for?
I'm not certain at this time. I don't have it in front of me.
Were any of the receipts for therapy?
Absolutely. More than half of what was sent was more than, let me be careful how I state it. A large portion of what was sent was for therapy.
Is this the you do?
Absolutely not. I do not think it was in good faith.
Objection. Non-responsive, number one.
Sustain.
And then number two, she's asking if it was medically necessary, but that has not, there's been no predicate to even get to medical necessity. They've not proffered any bills, any invoices.
Sustain.
So
We disagree.
Sustain.
Does your prior order specifically state that issues regarding elective surgery shall be made together?
Yes.
And did you agree to these charges? Did you agree to these treatments?
I'm sorry, which
GA, father and mother will discuss major issues regarding the children and make these decisions together. Major issues include, but are not limited to, elective surgery, education, general health, safety issues. Is that correct? And are some of these charges in your belief for elective surgeries or elective medical procedures?
some of them may be.
And did you agree to all of those?
I didn't agree to the surgery at all.
Extracurricular activities, do you know what any of these charges are for?
Some of them are for things that I did not consent to, and some of them maybe some of the kids stuff. Sammy J does track and field. There's basketball. Some of them may be in there, yes.
Dues for the extracurricular activity, or if they're for directly to the extracurricular activity fee?
Historically, a lot of things have been sent for shoes and things like that, and I.
leading.
Sustain, don't lead.
Okay.
So is it clear from this pleading what these are for?
Not all of them.
If you have a clarification of what these were for, would you be able to have the option, or not the option, but would you be able to determine if you can make those payments?
Objection, Your Honor, as to relevance, because willful compliance is totally separate from whether or not you agree to or have certain rights and duties as a parent.
Your Honor, he has to have notice in order to be able to comply or to be able to defend the suit. If we don't know what any of these for, how is he next to know what to pay?
Your Honor,
Hold on. Let me stop the time. Your client testified that he received some of these, okay? And
Correct.
he testified too that he knew what his role was. Now, to the extent, maybe not, but in essence, you can't have it both ways. It can't be he's on notice, but he's not on notice.
The problem is that he may have received a receipt for March 13th for 254, but not March 31st of 59. We don't know if he had these receipts, if there was a spreadsheet or anything that said what these were even for. Then he could say, oh yeah, it's clearly extracurricular, I'll pay it.
Yeah, but that's on him. He agreed that he received some. I can't. Right, but that's not the court's obligation. That's his responsibility to show what he received.
It's the petitioner's responsibility to show what she's.
It's her responsibility to show what she sent. Absolutely. But he's corroborated what she said. Maybe not all of it, but he's corroborated it. So for me to sit here and try to cherry pick which ones that he's on notice of, that's not my job as the court. She only has to prove one allegation.
But we can't assume that all of them are valid to do a final judgment because we don't know what they're.
Well, Your Honor, hold on. We cannot. That's not my role. She only has to prove one allegation here. One. He admitted, your client admitted under oath that he received some of them, maybe not all of them. You haven't put on his case in chief to show anything that he's received. Well, counsel, he's your witness.
Do you have any idea what receipts that you received of these?
There were some receipts in the parenting app that I had a lot of questions about. It was.
Okay.
What are the dates?
January of 2024 to November of 2024. I'm sorry.
Well, you can skip January 23rd because he admitted to that one already.
Did you receive a receipt for $142.58?
On what date?
January 23rd, 2024.
I don't have it
No, we're not doing that.
Okay.
He admitted that
Then
he did receive it. It's right here.
Okay, what was that one for? Do you recall?
I don't recall.
Okay. And was it for an extracurricular activity or health expense?
What does it say? I'm not certain. I don't have it in front of me at the time. I'm not saying it was a no. I'm just saying I don't have it in front of me.
Is it clear to you what activities, as far as, are you supposed to be paying? What constitutes an extracurricular activity?
I am unclear. Because I was under the impression that we would agree to some of these extracurricular activities, and we did not agree. I sent emails.
Do you understand what an extracurricular activity is?
Objection asked and answered.
Sustain.
Do you know if an extracurricular activity includes the cost of buying shoes at the department store?
I was told that I wouldn't be responsible for shoes and things like that. Ms. Smith sent me messages saying that no, we're not going to do that anymore.
Your understanding from the order that medical decisions would be made, elective medical decisions would be made together.
Correct.
And did you make any payments for medically necessary?
Objection again, Your Honor, as to this medically necessary characterization.
And have you ever been directed by anyone not to make payments?
Not to my knowledge.
And if it wasn't clear to you, is that why you filed a modification in this case?
I filed, if that's the reason, yes, there is a reason that.
Second, let me read the question. Overruled. You may ask the next question.
Why did you file a modification in this case?
I have not been clear completely on how This percentage remained all of this time with Ms. Smith, making far more money than I do. And I have a 73.9%. This was based on an old order. This has been changed since then. However, I am still being held responsible for times that she did not provide any income statements. So the percentage should have been different.
Second, wait on the next question.
Are you asking us to clear order so that you know what these charges are for and which ones that you're required to pay?
I would like the courts to go back and figure out the accurate distribution based on how much we actually made, so that I can be able to pay the proper percentage, because that's why I would, yes. Some of these charges are from prior to that involves this percentage that was incorrect.
Let me explain. I don't know if this has been explained to you. The order, as it was written at the time, you can still be held, you can still have violated, okay, at the time that it was in effect. Now, the 73% may not be what you're paying any longer, but while it was under the court order that you were ordered to pay that, you can still be held in. And you can, let me not say that word because that's not what I'm trying to say. You can still have been found to have violated it while it was still in effect. Does that make sense?
Yes, sure.
So anything regarding the 73.9%, if you did not comply at that time, that's the reason why that motion is here. Does that make sense?
Understood.
Okay.
I understand a little bit better now.
Okay.
Do you have any idea how much you would owe for extracurricular activities that are valid charges?
I don't know no.
The amount of medical reimbursements that are listed on here, do you know which ones you might be liable for under the order?
Some of them I understand since October 31st until now. I am willing to pay any of those outright. The ones prior, I did not know if we could get an accurate income distribution so that the percentage would be fair.
Okay, that's another thing. Thank you for saying that. That has nothing to do with today.
Okay.
Yeah, nothing to
Okay.
do. I'm only responsible for seeing which order was in place. Was it violated? That's it. Anything regarding income distribution, that's what you will do with my associate judge for the modification. Does that make sense?
Understood. It makes
There
better
are two
sense.
different hearings. I know it runs together, but they're two different hearings, okay?
Understood.
Okay.
Yes, Your Honor.
Isn't it true that some of these violations are from after the temporary order and were not under the prior order? So for example, there's a charge for November 6, 2024. Isn't it true that the Texas temporary orders were in place at that time?
Can you say that again? Sorry, I didn't understand.
Did the Texas temporary October 31st, 2020?
Correct.
So violations for any dates outside of that were not contained under the prior order. They're under the new Texas order. Is that correct?
Yes.
Your Honor, I just want to object, just to straighten the record.
What's the
temporary order?
what's the legal
The
objection?
legal objection would be that there's a mischaracterization of the timeline that she's giving for that. The court's record will reflect that the orders were not entered until after a certain amount of days or weeks after that
So
hearing.
this is what the court is going to do. The court is going to take judicial notice of all contents of the court's file.
So there was a rendition given on that date. Yeah, the orders weren't signed until we had them drafted, but the rendition was given as of the date of October.
Okay, so the court took judicial notice. That takes care of that. You may ask your next question.
Okay. I am with the question right now.
Okay. Attorney Nika, you have 1 minute and 57 seconds left. Attorney Johnson, you have 2 minutes and 23 seconds left. May this witness be excused?
Yes, Your Honor.
Okay, sir, you may return to your seat with your attorney, and counsel, you may call your next witness. Attorney Johnson, you may.
Thank you, Your Honor.
You're welcome.
Oh, Your Honor, I would like to call myself.
Okay, go ahead.
Second, I'm looking for. One thing, Your Honor, before I get started. Okay. Okay, Your Honor, I'm ready to proceed.
Go ahead.
Thank you, Your Honor. My name is Heather Nicole Johnson, and I represent Ms. Christelle Smith, the movement in this enforcement action. I'm requesting $7,500 in attorney's fees, which are both reasonable and necessary based on the time and labor required in reviewing the client's file in this case, drafting the proposed order for today and preparing for today's hearing. While an enforcement is common, Your Honor, this matter still involved quite a number of violations, tracking multi-date reimbursements and interpreting an out-of-state order that we later adopted in Texas. In terms of the skill required, the matter required a family law lawyer experienced with enforcement, contempt, and child support reimbursement. My flat rate is $7,500, consistent with attorney's fees the range for Dallas County for attorneys with similar experience and services. This is a flat fee agreement. The court's setting today on today's date required, preparation in terms of getting ready for this on Thursday when we were notified kind of last minute that we needed to pop on to get exhibits to the court. Also, in terms of what's required for me to demonstrate, I am an experienced Texas family law attorney with a reputation for being thorough, ethical, and effective. I have represented Ms. Smith since about April 28th, 2025 of this matter. And I believe that the $7,500 fee is proportionate to the results sought and the work performed. The similar awards of fees in this range for this type of action range anywhere from $5,000 to $10,000 and are commonly awarded in similar enforcement cases involving contempt. I'm just going through the Rasmussen, I can never say it, Rasmussen factors. Also, under those factors as well, this case is not what we would consider undesirable, but the complexity and the number of violations did make it more tedious.
Okay, counsel, you just ran out of time.
I'm sorry, Your Honor, but I'll pass
Thank you.
myself.
Thank you. Any questions?
Yes, did you bring an itemized bill with you today?
I did, it's in my bill.
And did you submit that as an exhibit with the associate judge?
I do not believe that I did with Judge Lee. I did not.
And how many hours?
Probably including the visits to the courthouse, I would say anywhere from 10 to 15, but let me make sure I have my,
How much do you bill per hour?
this was not an hourly fee
How
case.
much do you generally bill per hour?
$350.
No further questions, Your Honor.
Okay. Counsel,
Yes, I'm getting the bill right here. Sorry.
And you rest?
Yes, Your Honor.
All right. Attorney Nika?
Yes, we go Crystal Smith.
All right. Ms. Smith, you can have a seat in the witness box. Just make sure you pull the microphone close to your mouth.
Ms. Smith, on March 30th, 2024, you stated that you spent, is this $111 that you spent or how much was spent?
So any price in there is the percentage that he's held to.
Okay, so this is not the full amount of what you paid.
No, I put together a spreadsheet and I put it where I had my percentage, he had his percentage, and the total amount that it's cost.
Okay, so March 30th of 2024, what was that amount for?
I'm not looking at my spreadsheet.
And did you provide that spreadsheet to me?
Yes, ma'am.
Would you be surprised to know that I've never received any spreadsheet with any descriptions of these things?
Objection relevance, Your Honor.
Overrule.
I sent it to Mr. Smith.
Would you be surprised to know that well, never mind. So on April 17th of 2024, you're saying he owes $84.32. What was that for?
If I'm able to look at the spreadsheet, I can tell you, because it's very detailed. It's a very detailed spreadsheet of what the item was, the amount.
Would you agree that this doesn't include any of that information?
So I didn't draft that up.
But would you agree that this doesn't include any of that information?
You can answer that and that'll be your last question.
Repeat the question again, just to make sure.
I said, would you agree that this motion for enforcement doesn't include any of that information?
Any of what information?
Any of the information you're saying is detailed on a spreadsheet somewhere?
No, it's not. It does not have everything on it. No.
That's all you're.
Okay, thank you. Ma'am, you may return to your seat. I have a couple of questions. I'll start with you first, Ms. Smith. Each of the amounts due that you have listed on your motion, you said that that was what you sent to Mr. Smith?
Yes. Yes, ma'am.
Okay. How did you send notice to him?
I have an Excel spreadsheet and I also screenshot it since after the October 31st, I wasn't allowed to email him. I had to put everything in the parenting app. So there's multiple Excel printouts in the parenting app. Very detailed, explaining the date, the time, what it was, if it was a medication, if it was a doctor's appointment. He has all of that.
Okay, thank you. Were you sending him the receipts in real time or were you doing like a couple of days? How exactly were you sending him notice?
Real time, like, so if it happened within a matter of a day or two, maybe 3 days, he would have their actual receipt scanned, taken a picture and submitted in the parenting app prior to the temporary hearing. It was all in an email as an attachment. So it was the attachment.
All right. And just for clarification, because I don't think either one of you said it, the therapy, was that therapy for the child?
Yes, ma'am.
Okay. All right. And Mr. Smith, you testified that the kids were in track and basketball?
Yes, Your Honor.
Okay, and you are aware that those are extracurricular activities, right?
Yes, Your Honor.
Okay. And you said that you did receive notice from Ms. Smith in the parenting app?
Yes, Your Honor.
If you
For these charges, yes.
You have the list in front of you, right? The charges?
Yes, Your Honor.
Do you have you have the app on you?
I do have the app.
Okay, this is what we're going to do. We're going to take an intermission on this case because I need to catch these other two cases that are going on here. I want you all to pull those apps because, and this is so not typical, but I want to make sure that what you all, because your testimony kind of corroborates what she said. Now you're saying you didn't receive all of them. In order for me to put on you an amount, I have to know for me what that amount is.
Okay.
And I believe your testimony that you did receive some of them, and I'm going with that. I just need to know which ones you received.
Yes, Your Honor. May I have one more question, please?
Yes.
One of the more than well, about half of what was sent is a counselor who is her church affiliate.
Okay, that has nothing to do with what I'm saying.
Okay.
A service was used for the benefit of your child, regardless. Okay, so that's what we're going to do.
Yes, Your Honor.
Okay, so you all are on break. Miss Smith, Miss Smith. Did you all have an opportunity to speak? Okay, okay, let me move you all over. I was wondering why I couldn't see you.
Your Honor, when do you want us to come back?
Just check in whenever you're done.
Oh, just until they're,
Yeah,
okay.
the attorneys too. Yes.
Okay, can we leave our stuff or no?
Yeah, you can leave that there.
Okay.
You can leave your stuff there.
January.
Move to main session. Do you see me moving you to main session? Okay. So let me take you off. You can log off Zoom. All right. Okay, Attorney Hernandez, you're back.
Yes, ma'am. We were able to reach some agreements, and then we just have two things for Your Honor.
Perfect. You see how that worked? Okay. So let me pull your case back up. Hold on one second. And you all have to bear with me because the system is crashing on me left and right.
Okay.
If you all needed to go to the restroom, it's right when you got the doors, it's to the left and you make another left where the elevators are. You're welcome. Let me see. Okay. All right. So, Joy, I can't remember. Did we?
Nope.
Okay, that's what I needed to know. All right, everyone ready to proceed? Mr. Kincaid, would you remove yourself off mute and turn your camera on, please?
Yes, ma'am.
All right. We're on the record in cause number DF 2306791. Counsel, will you please announce for the record?
Alyssa Hernandez on behalf of petitioner Drew Kincaid.
Thank you. And ma'am, would you please state your name?
Amanda Smith.
Would you pull the microphone a little closer to you?
Amanda Smith.
Okay, and you are the respondent in this case, is that correct?
I am, Your Honor.
And you are proceeding representing yourself, is that also correct?
I am, Your Honor.
All right. Would you all raise your right hands? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
Thank you.
Yes,
You
Your
may
Honor.
lower your hands. So we're here on a petition for enforcement of a final suit affecting the parent-child relationship. The court encouraged the parties to speak to each other in one of the conference rooms, and it has come to the court's attention that there has been some progress, and you all have made some agreements. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Yes,
All
Your
right.
Honor.
Thank you. Attorney Hernandez, go ahead and read the agreements into the record.
Sure. And if Your Honor would like, I can preview not preview, but we have some agreements and then I can let you know the remaining issues if you'd like, or I'm happy to just read them if that's all you're asking for now.
You know what? Let's do it that way. Tell me the issues that remain outstanding.
Sure. So one of them is not an issue for you to really decide on, but I think both parties would benefit from Your Honor's clarification on what their order means on what a designated competent adult is. That has caused a lot of issues in their co-parenting, parallel parenting relationship, and I think both of them are seeking clarification on that.
Okay.
And then second, we are requesting attorney's fees on the basis of Ms. Smith's refusal to have settlement discussions with us.
Okay. All right.
Everything else has been agreed to. We've reached agreements.
Okay, perfect. So go ahead and read the agreement between the parties into the record.
Sure. So both the parties have agreed that Miss Amanda Smith will provide all of the child's Calvin Klein underwear, all of the child's Calvin Klein undershirts, all of the child's Nike socks that are in her possession to Mr. Kincaid by 5 p.m. on Friday. She is going to pay $20 to Mr. Kincaid also by Friday at 5 p.m. for a pair of missing Nike shorts, excuse me. She's also going to pay Mr. Kincaid $50 for the misappropriated trust funds that were used by Friday at 5 p.m. I am going to send the Texas DMV power of attorney form to Ms. Smith. She's going to fill that form out today and return it back to me for Mr. Kincaid to execute, and she will have the title to the Jeep transferred into her sole name by Friday. Lastly, the parties agreed to include a clause in the enforcement order, a mutual recommitment that they will both follow the final SAPSR order on a go-forward basis.
Okay. And Mr. Kincaid, is that your understanding of the agreement?
Yes, Your Honor.
Thank you. Ms. Smith, is that your understanding of the agreement?
Yes, Your Honor.
Okay, so the court accepts the agreement between the parties. And counsel, I'll be relying on you to give me an order that not only fleshes out the agreements between the parties, but whatever the court is going to consider on the attorney's fees, okay?
Yes, ma'am.
All right, so competent adults. A competent adult is just what it sounds like. Someone who is able to drive a car, put the child in a car, and make sure that the child is retrieved from one parent, take the child to the other parent. That's a competent adult. If it can't be anyone who is, when we say incompetent, so someone who is incapacitated mentally, right? That wouldn't be a competent adult. A competent adult does not mean that that person does not have a criminal history. I'm not saying that you all are designating anyone that does, but I just want to make sure it's clear, you know, if someone has a criminal history, if there are no legal orders limiting a person from being able to be around children, they're going to be considered a competent adult. It can be a new girlfriend. It can be a new boyfriend. It can be a new spouse. It can be a best friend. It can be a relative. It can be the preacher at church. It can be any of those people that I listed, as long as they are what's considered competent to make sure that the child gets from point A to point B. Yes, ma'am.
So in this case, Judge, it was a car service.
What do you mean a car service, like Uber?
No,
No,
like
Your Honor.
a car. It was a private vehicle, and a 17-year-old nephew or Drew's brother, youngest brother, 17-year-old in a car service, and he was not being directly delivered to his father.
Okay, the car service okay.
I can respond, Your Honor, if you'd like, or we were just seeking clarification, so I don't know that any argument is necessary, but if it's helpful, I can
I want
respond.
to hear from Mr. Kincaid, actually.
Oh, sure. Go ahead.
Okay, Mr. Kincaid, clear that up for me.
Yes, Your Honor. So David is a family driver for our family, has been a family driver for our family, meaning not just me, but my siblings, for my father. Miss Smith has also rode with him many times with Ronan in the vehicle, I may add. I did send my little brother also with him, um, just to make sure there was family there. And they were going to my dad's house where I was going to be a little bit later that day. And she refused to release him to a competent adult that she is very aware of, has ridden with many times. Ronan has ridden with many times. She knows exactly who this person is. He has all the certificates from the state of Texas to drive. He is a limo driver. He's not an Uber driver. He is a family friend who is our family driver.
Yes, ma'am.
You paid him, correct, to do that?
Yeah, okay, so we're not gonna get into all of that. It was
He
just,
also wasn't delivered to, Drew was not there. And why, if he was going to Drew's dad's house, Ronan's grandfather's home, where was his grandfather?
okay,
Why is there a 17-year-old? So David is dropping off a 17-year-old and a 7-year-old to a house that I don't know if when an adult is going to be there.
okay, so I can answer that for you. And I'm just gonna say it right out because I don't know any other way to say it. It's none of your business.
Okay.
When his child is in his possession, it's none of your business where his son goes as long as he's somewhere safe. Same thing with Mr. Kincaid. It's none of your business where your son goes as long as he's with someone that mom has designated him to be. And the reason I'm answering it directly like that because I don't want either of you to overstep and think that you have control to tell the
I appreciate that, Your Honor.
what they can and cannot do with your son. And you don't want me to do that because quite frankly, you all are the parents. I don't want to be the parents. I have a 17-year-old, I have a 16-year-old and a 6-year-old. And trust me, if I could give them to either one of you, I would because kids are expensive, right? But I know you don't want your kid either. I want you all to co-parent as best as you can. So yes, as long as he is safe and he is transported where the other parent that's receiving him, he's supposed to be, that's all that matters.
Okay.
Competent adult. And from what it sounds like, this is a competent adult. Your son has gotten back to you safe. And that's all really that I'm concerned about.
At the time, there was an inconsistency, with how both of us read that.
Right.
So, I mean,
and I understand, and that's why I'm here. So I can clear it up for you all. So now you all should not have any issue moving forward.
Okay.
Okay?
Yes, ma'am.
All right. The next thing, attorney's fees. What is it that you're asking for in attorney's fees, counsel?
We're just asking for a portion of our attorney's fees to be paid, considering Ms. Smith's, even her own admittance today that she refused to speak with us on settlement negotiations, even from the beginning when we filed this case.
Ma'am.
Okay, so let me just say this. Attorney's fees are something that the court, I can't speak for any other judge, but it's something that the court utilizes to ensure that orders are followed, right? I don't want to use it in a punitive way when someone is choosing to do something that they absolutely do not have to do. So mediation, any settlement, well, you all weren't ordered a mediation, so let me not use that word. Any informal settlement agreements, if either of you choose not to do that, you absolutely have the right to do that. And I don't want to make attorney's fees punitive because at this point, I think that's what it would be because she didn't agree to participate. I will say, even she told me no, but she did participate today. And that's all the court can encourage anybody to do. So I don't want to do that to anyone. So I'm going to deny attorney's fees. I just want to make sure that both parties understand this though. If for any reason you come in court on a motion for enforcement, I just want to make it clear that you understand that attorney's fees is a request that the court can't entertain, okay? The court is just choosing not to do so in this particular situation.
Okay, thank you, Your Honor.
Okay, so
Thank
if
you.
you would give me an order, Attorney Hernandez, I would appreciate it. How much time do you need to circulate the order?
I think I heard you give the last two cases 2 weeks. I think that's fine.
Okay, so I will add you on the same date as everyone else. It'll be November 7th, 2025 at 9:30. That'll be in front of Judge Lee. Now, if the order is circulated and signed, you all don't have to worry about that date at all. It'll just go away. But if it's not, then you would need to log on to the Zoom that day with Judge Lee and let us know what's going on, okay?
Okay.
Let me give you all the dismissal code when you're ready.
I'm ready.
Okay, Ms. Smith?
Do I need to write it down?
You can put it on your, like a note on your phone. Yeah. Okay, it's 961 1106 4392.
And to be clear, this is how I would log into the Zoom on that day on November?
Yes.
Okay.
If you need
If
that
we
date.
needed to.
Yeah, you
Okay.
may not need the date because you all came to an agreement. And let me just reiterate again, I appreciate you, Ms. Smith, even listening to me. You absolutely did not have to. I can't force you to do it, but I appreciate you going down the hallway and speaking, Mr. Kincaid. I appreciate you all for coming to some sort of an agreement because like I said, when you agree on your own, it makes it easier for you all to follow the order. Anything
Yes,
else,
Your Honor.
please?
No, ma'am.
Okay,
No, Your
we're
Honor.
free to leave. Thank you so much.
Thank you.
Thank
You're
you.
welcome.
Thank you.
You're welcome. All right, Texas versus Eric, is it Medellin?
Medellin, Judge. I'm here
Medellin.
on behalf of Movement, Eric Medellin, Judge. How are you?
Good, how are you?
I'm doing great, Judge. Thank you for asking. Respondent is also here, Ms. Jennifer Lopez, Judge.
Okay, all right. When I saw Jennifer Lopez, I didn't know if it was the Jennifer Lopez that was
Got you in the dancing mood.
Okay, have you all had an opportunity to speak? Like I said, you're not required to do that. I just like to give that option.
I think it would be beneficial for us to speak, Judge. However, this case isn't ready to proceed today. We don't have the return of service on file just yet, but she was served on the 10th of October, Judge. I was seeking for Ms. Lopez to receive her rights hearing today, Judge, and have her reappear for another date in the very near future, Judge, if that's okay with the court. We are seeking contempt and jail time in our petition, Judge.
Yeah, that's the issue because even though she's here, court would like to physically lay eyes on the return of service.
We filed it, Judge. The clerks just haven't accepted. And I can screen share showing she was served with both the order to appear, so we have the notice, and the return of service for our first amended petition. So she was served, Your Honor. It is on file, or it's been filed. It's the clerks haven't processed them, even though we've called to get it pushed through, Judge.
Okay, would you mind sharing your screen?
Definitely, Judge.
Ms. Lopez and Mr. Medellin, would you please turn on your camera? Thank you.
Permission to share my screen, Judge?
Yes.
So here is the notice, Judge, of the order to appear that was filed. This one has been accepted by the clerks. The return of service with citation was not accepted, but we've called the clerks to push it through, Judge.
Okay, so service was on September 5th.
No, service was completed the 10th of October, Your Honor.
Oh, okay.
We've been looking for her since September the 5th, Judge.
Sorry, I'm trying to read upside down. I'm trying to read to the side. Okay, so
here you go.
That is September 5th. Okay, I see it. Yes, the process server got it September 5th. She was served October 10th. Okay.
Yes.
So yeah, we can do the rights hearing. So that way, if we do have to we would have to reset anyway because today would actually be her 10th day.
Unfortunately, Judge, our civil process server did not get this on file until the 14th, so we wouldn't meet the 10 statutory days, Judge, based on his filing.
Okay, all right. So, Ms. Lopez, let me explain to you what a rights hearing is because you probably have no idea what I'm talking about.
Yes,
So,
ma'am.
anytime that an enforcement is filed, an enforcement is, if contempt is being requested, it's quasi-criminal, which means that there is a jail component attached to it. And as a result of that, by law, I have to determine whether or not you're what's considered indigent to see if you are entitled to a court-appointed attorney. If I do determine that you are indigent, and that'll be based on the testimony you'll give, based on a series of questions that'll be asked of you, I have to reset this hearing and get you a court-appointed attorney. If I determine that you're not indigent, then I would still have to reset this hearing for today. However, you're to either represent yourself or hire you an attorney for your next court hearing. Does that make sense?
Yes, Your Honor.
Okay. Joy, you ready? All right, we're on the record in cause number DF 2504248. Counsel, will you please announce for the record?
Alexandra Yanez, attorney for petitioner movement Eric Medellin.
Okay. And Ms. Lopez, you are the respondent in this case, is that correct?
That's correct, Your Honor.
All right, and you go ahead and raise your right hand. Mr. Medellin, go ahead and raise your right hand so I can swear you both in. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, Your Honor.
Yes, Your Honor.
Thank you. You may lower your hands. As stated, we are here on a motion for enforcement. I explained to you, Ms. Lopez, the purpose of the rights hearing. So at this time, Attorney Yanez is going to ask you some questions, okay?
Yes, Your Honor.
Okay, go ahead.
Ma'am, can you please state your name for the record of the court?
Jennifer Lopez.
And ma'am, it is true that you were served with both the citation for a first amended petition for enforcement as well as an order to appear on October 10th of 2025, correct?
Correct.
And based on that service, you have made an appearance for the hearing this morning, correct?
Correct.
And ma'am, what do you do for a living, Ms. Lopez?
I am a shipping clerk at a warehouse.
And who's your employer?
Highline Warren.
How long have you been employed by Highline Warren?
For maybe about a year.
And what is your current position there? Can you repeat that for me?
A shipping clerk.
Are you a salaried employee?
I work hourly.
How much do you get paid on an hourly basis, Ms. Lopez?
$22 an hour.
How many hours do you regularly work during a pay period, ma'am?
So I get paid bi-weekly. Maybe bi-weekly I put in 70 hours maybe.
Does your job offer opportunities to work overtime?
Not always, but yes, sometimes.
Okay, and how much is your overtime paid, Ms. Lopez?
I believe it's paid 33 an hour.
How often do you work overtime if you do?
Maybe once or twice a week.
And does your job offer you any additional compensation such as bonuses?
I believe it's yearly.
You do receive a yearly bonus?
Yes.
And what amount would that be, Ms. Lopez?
So it's determined based off of your work abilities and what you do. So not everyone receives it if they do believe that
in the past, if you have received
you are able to receive it.
My apologies.
No,
I think that was my liking. You have not received any in the past,
No.
correct? Okay. However, you've only been working for this company approximately a year.
Yes.
Okay, ma'am. And does your job offer you additional benefits such as a retirement account or vacation pay?
I don't believe so right now. I believe that's something that I would have to enroll for.
Okay, Ms. Lopez. And do you have any, what is your highest level of education? My apologies.
High school diploma.
Did you go to college?
I did start, but that's when I got pregnant, so I stopped. I didn't earn any degree in college.
Okay, approximately how many credit hours do you have as we speak?
Not many. I wouldn't be able to tell you exactly how many.
Okay. And ma'am, um, do you currently rent or own where you're living?
I rent.
Do you live by yourself, Miss Lopez?
No, I do not. I live with my mother.
Does your mother contribute towards your monthly household expenses?
Yes, we split the
Okay.
bills.
You split all the bills. How much is your rent in total?
$400 in total. What you mean in total, or what I'm paying?
What you can tell me what you pay, Miss Lopez. That's fine.
Okay, I'm paying $400.
Okay, the total would be 800. Correct?
No, the total would be 1,200. I do live also with my sister, so we split into three.
Okay, so all the household expenses are split into three. You, your
Yes.
sister, and your mother.
Mm-hmm.
Is your sister also an adult?
Yes, ma'am.
Okay, ma'am. And what about utilities? How much is your portion on a monthly basis?
On a monthly basis, I mean, our light bill is about $500, so that puts me around 100 and something dollars. Water bill is also $100 total. So for water bill, I only put in like $20, $30 max for water bill.
Okay. Do you have a car?
I do.
Do you own that car, Miss Lopez?
I do.
Okay. And how much do you have a note on it?
No, I do not.
Paid off car. Can you tell us the make and model of that car?
It's a Honda Civic 2011.
Do you own any other real property or personal property, ma'am?
No, I don't.
And how much do you approximately have in your bank account right now?
About $100.
Talking about your monthly income or monthly earnings, ma'am, you also receive child support from my client, Mr. Medellin, correct?
Correct.
And he pays his child support on time on the monthly basis, isn't that correct?
That's correct.
And you and Mr. Medellin share one child, correct?
Correct.
How much is Mr. Medellin paying for monthly support, ma'am?
I believe it's $724. That is split into two payments for the month.
Thank you, ma'am. I'll pass the witness at this time, Judge, and my requested relief based on the respondent's testimony is she has sufficient income with minimal expenses, Judge. I would ask that the court find that Ms. Lopez is not indigent and that she can afford her private counsel, Your Honor.
Thank you, counsel. The court does find that the respondent, Ms. Lopez, is not indigent. Ms. Lopez, like I stated, if I did find that you're not indigent, then you are welcome to hire your own attorney at your own choosing. But if you wish not to do that and you would like to proceed on your own, you can do that as well, okay?
Yes, Your Honor.
Okay, so let's get a reset date. I have first available, I have November 3rd, then I have November the 10th after that. And after that, it goes to December 1st.
I think November 3rd works for me, Judge. However, we are requesting an in-person setting because of our requested relief. Would that affect the court's availability, Your Honor?
No. Ms. Lopez, does November 3rd work for you?
That's fine, Your Honor.
Okay. Times that we have available. We have 10, 10:30, and 11 o'clock.
Either work for me, Judge. I would prefer the 10.
Okay. Ms. Lopez?
That's fine.
All right. So, Ms. Lopez, I'm swearing you in to reappear on Monday, November 3rd, 2025 at 10 o'clock a.m. at the 255th Judicial District Court, which is located in the George Allen Court Building at 600 Commerce Street on the 4th floor, Dallas, Texas, 75202. Your failure to appear may result in a KP's warrant being issued for your arrest. Do you understand those instructions?
I understand, Your Honor.
Okay, and do you have any questions about those instructions?
I do not.
All right. So, counsel, I'm adding that date to the docket. Would you like to, I mean, you all are here. I can put you in a conference room now so you can speak, or you can speak on another day. It's really up to you all how you like to do it.
Yes, Judge, for preserving the time, the court's time, I think it's best if we speak now, see if maybe there's a possibility of any sort of agreements, Judge.
Okay, Ms. Lopez, is that also your agreement?
That's okay, Your Honor.
Okay, you put you all, you're gonna get a prompt from room 2. So just, Attorney Yanez, do you want your client over there too?
No, Judge, he's in my office. I will just instruct him to mute and turn off the camera, and I'll confer with him as I receive any offers of any.
Okay, sounds good. Thank you.
Thank you for your time, Judge.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome. You all have a good day. Oh, well, you'll be back. Let's see. 2, 0, 2, 4. Okay, y'all give me 1 second. While the computer was working, I was trying to put a date in. Okay. All right. Let me see something. Okay, do we need to go on the record yet, or did you all need to tell me something?
Well.
I had a feeling y'all had to tell me something.
Yeah, it looks like none of these charges, spreadsheets for none of these charges are in the app. It's just the new stuff.
Okay.
Since the prior temporary.
Okay, so. Okay. What about the, hold on, let me pull that motion back up. What about the healthcare expenses?
It's all in one spreadsheet. She puts healthcare and extracurricular all in one from what I could tell.
Okay, so the spreadsheet doesn't, just so I'm clear, the spreadsheet doesn't have any of these dates.
Correct. The ones on the app don't have any of those dates. She says she sent emails before, but on the app are none of these dates.
Yes.
Okay.
Have two separate timeframes, Your Honor. There is a period through October 29th, 2024, where the parties had not yet been ordered to enroll in an app. So my client was notifying him via email.
Okay. Did y'all look at that?
Yes, and I was going to tell you. And so we have those emails because she was smart. My client's really smart, but she numbered each time she sent it 1, 2, 3. So we're all the way through 34 now.
And I don't have those emails.
So we have those. And then beginning November 14th, 2024, that's when the parties were enrolled on the app close. So that's why there should be subsequent dates, if any, in that app. For those.
Okay, so can y'all do that too with the emails?
Okay.
Yeah.
Yeah.
Because I know who lives out of town. You live out of town. Yeah, and I know you've been here a couple of times. So as much as I can kind of help mediate this, you know?
I mean, the only objection is that they didn't present the emails or any of that testimony or any of that evidence during the hearing.
But he admitted to receiving.
And that's my hang up, right? And that's really why I haven't went back on Zoom either, because he corroborated some of what she wrote here. So you all know this is not how a contempt hearing goes. You know this is not how a motion for enforcement hearing goes. But I'm trying to give grace because I don't want them to have to come back. And as much as we can get done today, that's what I would like to do. He admitted that she did send him notice of some. And I just want to know, were those these?
Yes. Well, how about this? If the court would like, I can go through them myself again through the dates in the motion. as well as my client's emails, and then send that to.
No, we're gonna do that today.
Well, no,
So,
I was
yeah.
gonna say I would do it today, but I'm saying like that way I can give her those, because I have to see it in writing. I can't.
No, I want y'all to do it right now.
Okay.
Just today. You all are already here. I don't want anybody to leave out of this courtroom not understanding what they're doing, because we're also going to clarify the order, because the order is real loose.
Right.
And both of you, for your sake in sending him notice and for your sake in receiving notice, because if not, y'all are going to end right back, and your attorneys can tell you, you'll end right back up in here, because your order does not specify how you're supposed to send notice and how he's supposed to respond after receiving notice.
Your Honor, some of these extracurricular activities, it's my understanding, are for summer camps and those sorts of things. I mean, how do we account for that? Is that summer camp is, in my opinion, an extracurricular activity, but it's not clear.
So y'all have a modification pending, right?
Yes,
You all are going to discuss that in the modification.
that it's not included in the temporary order.
Well, it may not be, but as you can see, it's an issue now.
Right.
So I think that that's something you all need to address at a temporary basis, because summer will be here before we know it. And then when you all see me at final, then we can discuss it even further. But I don't want that to be an issue on final that y'all have not addressed up until that point. I don't think that's fair to your clients. So yes, you all can go again and flush out that. Because I want to make sure that everybody walks out of here today with a complete understanding of what their obligations are. And we're in recess to lunch. If you all wanted to go grab lunch, you can come back. There's no rush for you all to come back. I can say, let's do like 1:15, 1:30. Okay, well, okay, all right. But you all are free to, there's a cafeteria downstairs. You're welcome. Mhm. Oh, okay. Attorney Yanez, Ms. Lopez, that was fast.
It's
Yes, Your
fast.
Honor.
It's fast when there's no agreement, Judge. But it's
Okay.
okay. We're still hopeful that maybe we can somehow resolve this before the third judge.
Okay, no problem. Well, you all have already been reset. Ms. Lopez has been sworn in, so I will see you all here in person November 3rd at 10 a.m.
Great. Thank you for your time,
Thank
Judge.
you,
May
Your
I be
Honor.
excused?
You all are excused.
Thank you, Judge.
Thank you, Your Honor.
You're welcome.
Judge, on an unrelated matter, I'm
Yes.
set for a trial before Your Honor on Thursday, but my client has asked me to withdraw. He signed an order for withdrawal. Would it be okay if I forward it to Joey for your consideration, or would you prefer that I walk it through?
I think the best way to probably do that is, so he doesn't want you to show up on Thursday?
Yeah, he doesn't want me to bill him for anything else.
Oh, okay. Well, I guess you can just send it to Brittany.
Okay, Judge, I will do that. Thank you so much for your time, Judge.
You're welcome.
You have a great day. Bye,
All
Joey.
right. Thank you. Good to see you.
Good to see you as well, Judge.
All right, so our 1 o'clock, they sent an email and we're rescheduled, so we do not have an afternoon docket. So I'm going to stop the live stream.